My best Lordship. Lordship, item 20 of the hearing. May I pray that it may be taken up the after tomorrow. I have some personal work at home. I've taken the consent from the other side.
Why day after tomorrow?
Day after tomorrow. Thursday?
Okay.
Oblige you.
Item number 20 be taken up there.
Meet this, my lordship. Lordship, I beg to mention item number 9. I'm asking the petitioner to provide me he got his salary, since his reinstatement, he got his salary only this month. So how much the petitioner is getting, I just want to know that, and it will be provided to me by today or tomorrow. So just give me 1 week to file the matter may come up next week. I will just file a small short affidavit, a reply.
Zinomi, the Learned Council submits that the petitioner would like to file an additional affidavit and therefore requests for some accommodation. Is the matter next week.
Obliged, lordship.
My lord, please allow me to mention hearing item 22. The matter may be fixed on Thursday.
Why? Why?
Item 22, hearing item.
Why Thursday?
I beg your pardon, my lord.
Why on Thursday?
I need some time to bring some relevant case laws.
It is that the case laws I will help you out. Don't worry. Okay, let's
But-
start a list. We'll hear you whenever you matter.
From the supplementary cost list for motion, item number 30.
Yes,
Lordship, the matter pertains to non-release of the undisputed pending appeal, Lordship.
completion when?
Completion was in the year 2010, Lordship.
So,
And the second is in the year 2011. There are two work orders, Lordship.
so why should we issue notice in this matter?
Lordship, I have approached the authorities on several occasions and
Understood, but 15 years, isn't it a very long time?
Lordship.
Why should we exercise our jurisdiction?
I have written representation in the year 2012 as well as 16.
Huh?
Yeah. I have submitted representation in the year 2012, Lordship. And a reminder was also submitted in the year 16.
These are of 2010. Why should we at all issue notice in this matter? We have last issued a legal notice in 2022, 4 years back. So we dismiss it.
Lordship, if your Lordship may kindly appreciate that
No,
he has
I don't-
invested all his resources.
I
Lordship.
can't help it. If he could wait for such a long time, go file civil suit.
Lordship, the amount is undisputed, Lordship. In fact, the authorities.
If it is undisputed in 2010, obviously you should have approached this court in 2011, 12, or even in the year of 2010 to 2020. We are in 2026.
Lordship, the petitioner had difficulties, Lordship. The
No,
approach is
can't help it.
Because he has already
therefore
invested all his
dismiss
resources, Lordship.
your petition.
Lordship, my limited prayer is if.
No, the thing is that they must have lost the papers. It is difficult for them to do tomorrow what order we can pass that you kindly verify. They can't verify it. Because it is a case of 2010. How can they verify?
There's also a communication between the two authorities, Lordship. The executive engineer, Lordship, he has written to the chief engineer, Lordship. Now,
No.
he has admitted in the communication, Lordship.
When?
Lordship, it was in the year 2011, Lordship.
So Again. Chalo, with
Lordship,
this-
well, very limited prayer, Lordship. If
You-
the direction may be issued to
everything-
verify, Lordship.
No, nothing.
Verify the
Absolutely no. This is a case for dismissal right away.
Lordship.
Heard Mr. M. Jamid, the learned counsel, appearing on behalf of the petitioner, Mr. So-and-so, who appears on behalf of the respondent numbers 1 to 5. The present petition has been filed by the petitioner. Seeking a direction upon the respondent authorities to pay certain amounts which, as per the petitioner, is an undisputed amount, along with interest at the rate of 18% per annum. This court duly takes note of that in the year 2010, the petitioner was granted a contract for maintenance of the Dimapur to Ganesh Nagar Road. Of a value of rupees 37 lakhs 17,200. It is mentioned that the said work was completed on 9/11/2010. It is further seen that while another contract dated 5/9/2011, another work order was issued for improvement of town road at Dimapur opposite road, DMR opposite road to Bank Colony, Dimapur. It is also mentioned that the said contract was completed on 27/9/2011. It is the case of the petitioner that the said amount have not been received, for which the petitioner submitted a representation on 15/2/2012. Thereupon, another representation was issued on 29/2016. And finally, a legal notice was issued on 25/10/2022. It is the case of the petitioner that in spite of these representations, as well as the legal notice so issued, the respondents have not made any payment. Mr. So-and-so, who appears on behalf of the respondents, submits that the claim of the petitioner, if at all true, is a claim of the year 2010-11. And it would be difficult for the respondent authorities to trace out any of the documents taking into account to verify as to whether the petitioners are at all entitled to the amount so claimed. A valid defense of the respondents in the instant case learned counsel further submitted that in the circumstance any writ is issued in the instant proceedings, a valid defense of the petition of the respondents to carry out any verification would be lost. And under such circumstances submitted that this court may not like to entertain the petition. This court have duly taken note of the respective submissions and have also perused the materials on record The materials on record show that the petitioner was granted the work orders in the year 2010, one work order in the year 2010, and the other work order was issued in the year 2011. The completion, as claimed by the petitioner, was sometime in the year 2010 and 2011. The petitioner waited for a long 15 years to approach this court for any directions passed in the instant case, directing the respondents herein to verify and to make payment would become a difficult proposition for the respondents to comply, taking into account that they may not have the relevant documents with their possession. A valid right of defense, which the respondents have, would be taken away if any writ is being issued. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Chennai Metropolitan Authority versus so-and-so. You take that citation from sense.
Sorry for indulgence, Lordship.
The Supreme Court observed that approaching the court at that delay and laches is one of the pertinent aspects which needs to be taken into consideration while exercising the jurisdiction. Paragraph so-and-so of the said judgment being relevant is reproduced hereunder. In the instant case, it is the opinion of this court that the petitioner have approached this court. The instant writ petition suffers from delay and laches. There is no explanation in the instant writ petition as to why the petitioner have approached this court after a hiatus of 15 years. Under such circumstances, this court is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. Next. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not prejudice the petitioner to approach the competent civil court, if so advised.
Obliged, Lordship.
For admission, item number 1.
May I please, Your Lordship?
Yes.
Your Lordship, I have received the parawise comments last week. It's under preparation, so if I may be given some time.
What is the matter about?
The regularization, Your Lordship.
Well, what
So,
is
Your
there
Lordship,
to
initially
regularize?
when the writ petition was filed, there were 106 petitioners. 80 of them has been regularized. And somewhere in September, in the month of September, the petition was amended again, deleting all the regularized petition. Now again, Your Lordship, one more petitioner number 9 has been regularized.
So now how many petitioners?
Now 25 remains, Your Lordship.
26.
Out of 26, one has been regularized and 25 remains. Now again, Your Lordship, out of these 25 petitioners, petitioner number 8 and 9.
Yes. Are in the process of being regularized.
No, Your Lordship. Petitioner 8 and 9, they have not enclosed their code number or appointment orders or their details in the writ petition. Now, Your Lordship, work charge employees, all work charge employees are given a code number and they are identified by this code number. Without having this code number, it is difficult and it's not possible for the department to trace out their details because there are many work charge employees who have similar names and similar titles. So, Your Lordship, if the petitioner can provide the details with regard to petitioner number 7 and 8.
Of the amended writ petition.
Yes, Your Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. A. Amin, the learned counsel appears on behalf of the state respondents. The instant writ petition was filed initially on 29/1/2024 by 106 writ petitioners claiming their right to be regularized in terms with the office memorandum dated 17/3/2015, isn't it?
Yes, Your Lordship.
First, Ms. A. Amin, the learned counsel submits that in the meantime, 81 writ petitioners have already been regularized. First, this aspect is apparent from the fact that the petitioner also admits the same, as would be apparent from the amended writ petition which is being filed, where now, presently, there are only 26 writ petitioners. First, Ms. So-and-so, the learned counsel appearing on behalf of the respondents further submits that in the meantime, the steps are being taken to consider the case of the petitioners for regularization in terms with the office memorandum dated 17/3/2015. However, in respect to the petitioner number 7 and 8, no steps can be taken for consideration of their case for regularization, as they have not provided the code number which is issued to each work charge employee. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that within 7 days, the code number of the petitioner number 7 and 8 shall be provided to Ms. AME. First, taking into account the above, list this matter in the month of May, in the third week of May 2026 for an update.
For admission, item number 2.
May I please, Lordship? Lordship, I have received the affidavit in reply filed by the petitioner just outside the court. So if I will be allowed some time to go through, Lordship.
You go through it while you have let both of us go through it together.
Lordship, I'll
Are
be
you?
filing during the course of the day.
You have not filed.
I've served a copy, I have not filed.
You have not filed.
I'll
Don't
file it-
file,
I'll
not
file it
necessary.
during the course of the day.
What is your case about?
It's about the appointment of the private respondent.
Huh? What are you challenging?
The appointment of the private respondent, Lordship.
Who is the private respondent?
Respondent number 5.
You are
Lordship.
appearing.
I'm on behalf of.
On what
The
basis?
Land commissioning,
Land ownership.
Lordship.
Has the verification been carried out by the deputy commissioner, madam?
Uh,
In terms with the notification dated 5/3/2018?
Lordship, respondent number 5 was appointed, the post was advertised. And the petitioner, the respondent 5 was also participate. Accordingly, on the ground of merit, the respondent 5 was appointed, Lordship.
Oh, then what case do you have?
And on the basis of land ownership, has
Lordship,
already
that will
appointed,
go.
Lordship.
Not
Lordship,
necessary.
The verification is challenged, Lordship,
Why?
because the information was not
No,
conveyed.
no,
to
that's
the-
what this is nothing to do with land ownership appointment. It is appointment on
No,
the
like,
basis
no.
of advertisement.
No, Lordship, it is on the basis of, they have stated that I have been, the law of perpetuity does not arise here.
No, no.
Whereas-
My question is, if the post was advertised
Okay.
and you participated in pursuance to the advertisement, then can you claim out here now to say
No,
that
no,
the
Lordship,
appointment of the
the
respondent number
principle
5
of
is wrong?
Lordship was
Because
not
you-
applied.
Absolutely, that is a different aspect, whether it is complied or not. When there was an advertisement, you should have challenged the advertisement. Where is the advertisement, madam?
That was in the respondent number 5 affidavit, Lordship.
Huh?
Respondent number 5 affidavit into position, Lordship.
Okay, let us see that. Respondent number 5's affidavit in opposition.
Annex 2, page 8.
Ah, where? Deputy Commissioner? Who has appointed? What is the post?
Money, Lordship.
Mali. By whom? There are 3 advertisements.
Lordship.
Which one? Please. Who is for appearing for response number 5?
I'm appearing on
Okay, where is that advertisement?
Your Lordship, since I'm not the main counsel here,
You
I was
become
distracted.
only the small counsel, but then also just tell me where is the advertisement? When I am in your favor, you should be helping the court. What is the post? And get me a magnifying glass. What they have done is you can't see anything.
MTS multitasking.
Which one? Is it by the Director of Health and Family, or by the Office of the Deputy Commissioner, or the Empowering Electricity Consumer? Which one?
Piece of Deputy Commissioner.
Deputy Commissioner. Okay. In pursuance to the approval of the government, Nagaland so and so, offline area are hereby invited from eligible indigenous inhabitants of Kipri for filling up of 3 posts of multitasking staff under the district administration. Okay. Now, in pursuance thereto, the petitioner submitted. Let us see what is the points of the petition. Mr. Counsel, kindly come to paragraph number 5 of your petition. What is this interview base? Is it in pursuance to the
Lordship,
this
Because of the-
interview is what?
for MTS in the office of EAC Sitimi, but the land verification was given by another EAC.
Understood. But the question is, you are challenging an appointment made on the basis of an advertisement. Okay. Now, in the advertisement, you have not challenged this advertisement. In the advertisement, there were 3 posts of MTS. Okay. As I could see from the annexure of that particular person's response number 5. Now, if you see this, in pursuance to the advertisement at page 30 of your petition, these 3 persons have been appointed,
Lordship.
of which you don't like somebody. Whom do you don't like? You don't like Amitoli A. Achumi.
No,
You
Lordship,
don't like her.
our challenge is on the basis of our reply to the affidavit in opposition, annexure 2.
No, understood. This is in pursuance to an advertisement. And they have been appointed. Your right of land ownership remains. It will continue. So next time they should consider that. But when you have participated in the advertisement, pursuant to the advertisement, then in that case, how can you say that why the appointment has been not being made on the basis of land ownership? Problem lied there, you see. This was an open advertisement. Your right as regards land ownership, they will consider later on, maybe somewhere else, if another vacancy arises. But the question remains out here. This is in pursuance to this. Isn't it, madam?
Lordship.
Am I wrong?
No, Lordship.
Get the point. Either you should have challenged the advertisement, you have not. You are challenging this order after having participated in the advertisement. We dismiss your petition without prejudice to your right of land ownership, which will be considered by them later on. That is the only thing I can do.
Lordship, let it be possible.
Why?
Principal counsel is-
You are the main counsel for me. Your principal counsel would not change the thing. This is what has happened. Who is the principal counsel?
NK will come.
Huh?
Mr. NK will come, Lordship.
So fantastic. You are there. If he was there, I would not even use the word without prejudice. With you, I can use that word. That day in the principal seat, one matter was going on. The other side had a good case. So this side, there was a young counsel who was very recently appointed, he recently joined the profession. So she was appearing out here. I said, okay, let me think about it, how I can do something for you. This was at 1 o'clock. 2 o'clock, she gets hold of her senior counsel. So I then say that as now you have a senior counsel, why should I take that help? So I gave the petitioner the entire relief without giving anything to it. I told him, you may check the video. 2 o'clock on Friday, you will see it. This is what has happened. Same thing. Here, you have a right of land ownership. There's no quarrel with that. That will be considered by them subsequently. If another vacancy arises, they will consider it. If you have a right of land ownership. But in this case, as there is an advertisement at all, and you have participated in pursuance to the advertisement, and you have not challenged the advertisement, how can I help you out?
My prayer says, set aside the
And why do you don't like? Why don't you like what you call
It's
the
based
response
on
number
the
5?
recommendation of the commissioner, Lordship.
Why?
So I'm challenging the approval appointment of by the.
Why? Because you have land ownership right.
Lordship.
That is why I'm saying.
They are saying that I have already enjoyed the facility, whereas I have not enjoyed.
Where is it? They say that we have enjoyed. Let us see the
They're putting in a
affidavit of the
box.
respondents. 1, 2, 3.
The government,
Yes, let us see the government affidavit. The grandfather of the petitioner was one of the land on the site of the wherever the land as per the verification reported here, but it is a common family land of late Havika and himself. So and so humbly stated a detailed report of so and so in the status of the employment of 2 donors of significant 2 landowners have already employed above. Therefore, the petitioner cannot give another appointment on land ownership basis in perpetuity violating so and so. Also clarified that it is not the policy of the government to provide employment in perpetuity. That it is in this urban sphere of the 19th year. That you also clearly put the No, you see, here we can do one thing. We ask the deputy commissioner to look into the question under 5. section clause 3B of the 5/3/2018 in your right claim as to whether it has been done. That is a finding of fact, which I can't look into it.
Lordship,
But you have no right.
no, Lordship,
No right.
their government recommended appointment of respondent number 5 is based on the report of the EAC CHO. Whereas the post is, the land is under EAC Sitimi.
Lordship, respondent number 5 was acquitted on the basis of the minutes of the DLRB meeting conducted on 22 September and 25.
Hmm? No, this we can't help it, the council. In this matter, it is in pursuance to an advertisement.
And Lordship, on the basis of land ownership, several persons have already
Of
been
the
acquitted.
advisement, but it is, we are challenging the verification report of the.
That is the immaterial. This is a
Because-
no, Mr. Counsel, it is a case of selection process. A selection process by which 3 persons have been chosen. In pursuance to this, if your case is that you have a land ownership right and as such you should have been chosen, that is not on the basis of an advertisement. That is on the basis of an application, if I'm not wrong. You don't call for advertisement for a land ownership basis, do you? Do you call for advertisement on land ownership basis? No.
Lordship, yes. 50%, as per the notification, 50% is there.
Where?
In the affidavit in reply to the affidavit in opposition of the respondent number 5, we have submitted.
Which dated?
The notification from Office of the Commissioner, Nagaland, dated October 18, 2022, page 24, R, annexure R.
Page
Page 22.
huh? 18th October 2022.
The type of PSH, it's 25.
No, understood. All are understood. You have a right, whatever may be, you may not have a right also as per them. But there is an advertisement where it is being done in terms with calling anybody. This is the advertisement,
Not sure.
Annexure 5. When there is this advertisement, you can't go away from that. No? And you have not mentioned that in pursuance to the advertisement you have applied. Did you apply?
Lordship,
Huh?
I've stated in my petition.
Where?
I have annexed in page 28, next your F. Admission certificate, Lordship, where I have participated.
Understood, but you have not clearly stated why. Why
It
this
is
ethnic
based
card
on the verification report, stating that I've already enjoyed.
Mr. Counsel,
I was not,
where have you said that there was an advertisement in your petition? Not a single word. No. I think we passed out.
Lordship, let me pass over for the.
Time being. Time being I can give you. Not day. Time being. Day is lost. Haven't you seen your learned colleagues out there fixing the matter from today to Friday, Thursday? When do I do it? Tomorrow is Wednesday. But with the council, your entire petition is wrong. And I may say, don't take it otherwise, it's a case of suppression. You, pursuant to an advertisement, you participated. You did not get it. Now you say that this particular person has been appointed against that post which fell vacant on account of his retirement. How do you identify that this is against that post when your right is 33%? The 33% as per the addendum of 18th of October 2022 is maybe in entire thing. You can identify that this post has become vacant, so this is against that. You will have any other post. That is one. Secondly, they deny to the effect that there is a case of against you. That your family, it was a common land. And this family, your family have already taken two
Your
posts.
Lordship, we are denying that. It is a
Understood, Mr. Counsel. They are saying so.
Lordship,
You are denying it.
Lordship.
Let the Deputy Commissioner look into that. That is another aspect of the matter, which I can't decide. How can I decide? The power has been given as per the notification of 5/3/2018 to the Deputy Commissioner. Isn't it? 3B. So how can I decide that? I have to take your word against his word or her word. How do I decide that? It is on the basis of evidence they have to look into it. The only thing which I can do to you is, as regards the claim of land ownership, let the Deputy Commissioner decide and you prove it for that. So in respect to future jobs, any other retirement happens, you'll be taken into account if you have it. That is the only thing one can do. Otherwise, your reputation should be dismissed on the face of it without you going into all these disputes. I think we should dismiss it right away without going into all this. What do you say?
Lordship, I leave it to you, Lordship.
Huh?
I leave it to you, Lordship.
Lordship, let me pass over for the.
No, we dismiss it right away now. What is there to be passed over? You get it by 2 o'clock, your senior, whoever it is. Then I will. But then I tell you, I'm not going to go into the second aspect. You think about it. We'll call it up again at 2. Now, if you are appearing, I can go into the second aspect. But if your senior is appearing, only the first aspect. Dismissal on suppression of material facts. 2 o'clock. Get hold of your senior also. I think you are enough.
If I may, Your Lordship.
You are enough. I'm in your favor.
What advice?
For admission, item number 3.
Yes, madam.
By already February 2026, the Senate State Council was instructed to get some direction from the instruction from the respondent authorities, for more particularly respondent number 4.
Why?
What you say?
Why are you challenging the appointment of respondent number 4?
On the ground that the junior was considered, I'm the senior most in the establishment, Lordship, and a junior was considered for regularization.
Regularization?
Yes, Lord. Now it is the stand of the state respondents that the respondent number 4 was regularized on the basis of land ownership, Lordship. Now there's a policy in the state of Nagaland, 5th March 2018.
That's not the concept of regularization is possible under land ownership basis.
Yes, Lordship.
Is it possible?
No, it's not possible, Lordship.
Not possible.
Your Lordship, in this matter, my colleague Livika is appearing. So she was, earlier occasion, she was instructed to get the instruction where the verification was done in this matter. So she stated that verification by RO has been done and the report has been annexed in the affidavit, Your Lordship. They're in the annexure.
Let's see the affidavit filed by the respondents. Respondent number?
1, 2, and 3, Lord. The document the state is relying is page number 25, Lordship, the last page.
Where is the affidavit? One affidavit I find.
In opposition filed by respondent number 1, 2, and 3, Lord.
Let's find it out here. Where is it? No affidavit.
1, 2, and 3.
One is regularization. This case is of regularization. What the petitioner is asking for some. I have only one affidavit filed by respondent number 4. Which 4? Let us see the appointment order of the respondent number 4 in your petition.
Page 26.
This is done on the land ownership basis. It is in fact not a question of regularization. It is being given appointment, and thereby why they have used the word regularization is only to give the additional benefit of your earlier years of service. If you see page 23, see the minutes.
Yes, Lordship.
Then
They have recommended on the basis of land ownership.
so
Now, Lordship, there are two aspects, Lordship.
Mm.
As far as if an applicant is to be considered on a basis of land ownership, Lordship, the clause 3B has to be fulfilled, Lordship. Now, a verification has to be done by the concerned deputy commissioner, Lordship. No, there's no such report of the verification conducted, Lordship. Secondly, Lordship, the department has purchased the land, Lordship.
Mm.
Now, the question of regularizing or appointing on the basis of land ownership does not arise, Lordship, because there's already a partner issued in the name of the department, Lordship. They have purchased. It was an outright purchase, Lordship. The question of regularization or any other benefit does not arise. I have the patta, Lordship, and patta issued in favor of the department, Lordship.
when was the patta issued? Where is the respond numbers 1, 2, and 3 is document? Affidavit.
Or Lordship. The last page of the affidavit.
No.
There's a development order in the year 2016 and patta was issued on 17 February 2016.
Where?
Lordship, I have.
Which document?
Lordship, it's with me, Lordship. I'm here to file an affidavit enclosing this document.
No. Yeah, don't know. You are claiming right of regularization.
Yes, Lordship.
His case is not a case of regularization.
Lord.
It is a case of appointment made on land ownership basis. So your right and his right are totally different.
Yes, Lord.
Then
And my contention is that
you will be
it cannot be
entitled-
considered on the basis of land ownership.
why should we go into
Because
that?
they have to fulfill the criteria, Lordship.
No, why
Provided that-
why should we go into that? Taking into account that a person who's otherwise have a land ownership right, you may be a person aggrieved for him.
Lordship.
You have no right.
Senior-
You have a right of regularization, no doubt. That will be
Yes.
considered.
Yes,
As
Lordship.
per, if you have completed 30 years, as per 17/3/2015, if you have completed 30 years and if you are in the scale of pay, you will be regularized. That is a different thing. Here, the petitioner, it is a case of appointment on land ownership basis. The word regularization has been used only for the purpose of giving certain benefit to the respondent number 4 for earlier period of service. Otherwise, nothing. Otherwise, it would have been a fresh appointment. It is the government who has been more kind to the respondent number 4. It's a different aspect of the matter.
Lordship,
Taking
for
into
appointment,
account-
Lordship, there are two things, Lordship. There has to be written agreement between the department and the landowner or an oral agreement, Lordship. In this case, there's no such written agreement, Lordship.
No, there is the last document at page 24, 25 of this affidavit filed by respondents. Category clause so say that this is to certify that KVJ so-and-so, son of so-and-so of Khel so-and-so is one of the landowners whose land was acquired at the new secretariat so-and-so.
What it merely says that his land was acquired, Lordship, but the record shows that it was purchased, Lordship. I have the records with me, Lordship. I may be allowed to file by way of affidavit,
No,
Lordship.
why should we allow
I'll
this?
file it in 2 days, Lordship.
Why should we allow a diversion of the matter? You are not, your claim is qua 17.3. Your claim is on 17.3.
Lordship.
17.3, 2015.
As well as 2004, Lordship. 2000.
15/9, 2004. When there is a vacancy out there, you are work charge.
Lordship, I'm serving on contingency basis, Lordship.
Contingency to 17.1.
Now,
It is
2025 covers my case, Lordship.
only that is qua 17.3.
Lordship, there's
No.
Roman 3 is there, Lordship.
No.
Roman 3 says about 2004, Lordship. Roman 3, Lordship.
No, 1 Roman 3 is different. 1 Roman 3 is a completely different aspect of the matter.
It
You
says
don't
about the
have-
existing policy, Lordship.
Here, 1 Roman 2 will apply for you as well as the addendum which has been issued, or that notification which was issued on 3/2025.
Yes, Lordship. That has included even 2004, Lordship.
So no, they are saying that any person who is fixed contingency and so shall be regarded as casual employees for the purpose of 17(3).
And paragraph 3 clearly says, Lordship,
I
the
don't
persons,
see-
the employees who are
I don't
verified.
see any
Lordship.
paragraph 3 and all.
Paragraph
You
3.
give him the central metropolitan, Chennai metro. No, I think we should dismiss.
Paragraph 3, Lordship.
We should dismiss. What do you see, madam? Dismiss.
Lordship, for
Your Lordship, I leave it up to.
We should dismiss this. You have a right to just look.
Notification, Lordship, the second page. The first is the OM 5th March 2025, and the second is notification 5th March 2025. That is also the same date, Lordship. The paragraph 3, Lordship. The employees who are verified will be eligible for regularization under clause 1, Roman 1 and 3, Lordship. Now, Roman 1 says about the employees who completes 30 years of service, and Roman 3 says about the existing policy, Lordship.
Now, one Roman 3 is different. Let us see Roman 3. What the
Roman 3, yes, Lordship.
What is it? The
Roman 3 of
existing
2025.
No, Mr. Muazzam, one Roman 3 is what happened for a period of 5 years or 10 years, whatever may be. They have extended the period. The
For 5 years.
amount which would be taken, that is 67% would be taken
50
for
to
5
60
years.
Yes, Lordship.
This I have held it in a division bench, so nothing.
But the employees,
Right.
Lordship,
No right. Under 15(9), there is no right. We dismiss your petition.
Lordship, I kindly come to notification, the
No,
5th,
enough.
5th March 2018, Lordship.
Chalo.
The last document,
No.
page 27, Lordship.
Today, bad
Page
day.
27.
You started your
Only
day
this.
very poorly today. Getting a motion dismissed at the first item in the day, it's a very poor thing. And
Lordship.
in fact, it is becoming day by day. This is the second one. We have just reached item number 4.
Four
Mr.
more.
Muazzamir is getting 2 dismissed. Huh?
Lordship, for a moment, if your
Hello.
Lordship may kindly allow me to.
I think this-
Page 27.
No,
Lordship.
no, don't trouble. It is not a regularization. This is an appointment on land ownership basis. Your right will be duly dealt with under 17(3). Now you will be getting it.
Lordship, in that case, I may be allowed a week's time, it's just a week's time to file an affidavit. Lordship, I
For
have
what?
some reports, Lordship.
No, why should we bring into you? No.
It's relating to the appointment
No,
of the
Mr.
respondent.
Counsel, Mr. Counsel, then your case has to come within the ambit of a writ of quo warranto. This is not a writ of quo warranto. You are asking a writ of certiorari.
Lordship,
Quo warranto is a person cannot hold the
Right.
public office as he doesn't have a qualification. Otherwise, it is not that the respondent number 4 does not have a qualification. The respondent number has a qualification, and it's just because for the post of MTS, there is no requirement of a qualification to that effect except section class 10 or whatever may be passed, which he or she has it. So therefore, a writ of quo warranto won't come. Otherwise, you have a problem with your locus. The moment he is being held that he is appointed on land ownership basis, your locus goes because you come in a different category altogether. Matter of what?
First, he has to fulfill the.
Understood. So that is
Conditions,
the
Lordship.
case of quo warranto, but you can't have a quo warranto against him because quo warranto is otherwise file a PIL.
We'll fix it next week, Lordship.
PIL.
Next week.
Next week when I'm taking division, come up with a PIL. Now in the
Lordship,
meantime,
next
let
week.
me dismiss
Lordship,
your.
kindly
Otherwise,
fix it
next week, how can you file a PIL without this? We dismiss it, right?
Lordship, a week's time, Lordship.
No, your case of regularization is for his post. That cannot happen because he has been appointed on land ownership basis. Matter ends.
Lordship,
It's a
for the interest
simple
of justice,
matter.
just a week's
A
time.
matter of no.
A week's time, Lordship.
No.
I'll file a reply, Lordship. There are some documents, pertinent documents, Lordship.
No. Look, heard Mr. Muazzamir, the learned counsel, appearing on behalf of the petitioner. Miss AIMA appears for the respondent numbers 1, 2, and 3. Mr. So-and-so appears for the respondent number 4. The petitioner herein is aggrieved by the regularization of the respondent number 4 to the post of multitasking sweeper on the ground that the respondent number 4 is junior to the petitioner. The facts as it appears from the materials on record are that by an order dated 9/8/2001, the petitioner was initially appointed as a grade 4 sweeper on contingency basis in the scale pay of 900. It is a fixed pay, not scale pay.
Lordship.
It's fixed pay of rupees 960 per month. The petitioner was posted under the establishment of the Directorate of Sericulture, Kohima, Nagaland. On 30/6/2023, a vacancy arose in the post of sweeper due to the retirement of Srimati Kono Koso under the Directorate of Sericulture, Kohima, Nagaland. Against such vacancy, the petitioner submitted an application dated 7/6/2023 for regularization of her service for being the senior most sweeper. The petitioner's application was recommended. The petitioner claims that the petitioner's application was recommended by the Chief Minister Nagaland, who is also the Minister.
Sorry, intelligence. In that case, I may be allowed to withdraw it, Lordship. File.
What?
Lordship, I may be allowed to withdraw it.
Why? You don't want to dismiss it.
Lordship.
Okay. Mr. Muajami, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition. Also, Ms. AME appears on behalf of the respondents. Numbers 1, 2, and 3. Mr. So-and-so appears for the respondent number 4. So taking into account the said, the instant petition therefore stands closed on withdrawal. Interim orders, if any, is not negated.
Obliged, Lordship.
For admission, item number 4.
Yes.
May I please, Lord? This matter is similar to item number 1. The item number 1, which was
35
case
years.
for regularization on the basis of the office memorandum of 15/3/2015. But at this stage, Lordship, 2 orders passed by this honorable court may be relevant. 5/2/2026, and then 3/2/2026. First, 5/2/2026.
Yes.
Lordship, the petitioner case is under consideration. So when the LBC will sit, the case of the petitioner will be considered, Lordship. The case of the petitioner has already put up to PNR, Lordship. If I may be allowed to.
Let there be a time bound.
So Ms. So-and-so appearing on behalf of the respondents 8 submits that the petitioner's case is under active consideration for regularization. And it is also submitted that presently the petitioner's case is with the PNR department. Taking into account the above, list this matter on 23rd of April 2026 for an update.
For admission, item number 5.
Yes, what is this, Mr. Limpo?
Order dated 7/8/2025.
Why, what is the matter?
matter
Any
regarding the
order dated
appointment of-
later on. What case you have filed?
Appointment
Land
of
ownership,
land ownership.
what happened? With the mandamus impugn approval letter dated an appointment letter and direct the response to appoint the petitioner, which we can't do. I can only see what is the appointment. Where is the approval letter?
The approval letter is at page number
13/12/2024.
Should be a pitch himself.
Consequent upon the approval of the government of Nagaland, it is so and so. The following is hereby appointed as medical attendant as so and so, so and so, so and so. This is appointed on what? Land ownership basis?
No, Lordship, the appointment without any selection process. Lordship,
Landowner. I was appointed on landowner.
Land ownership.
Lordship.
Lordship, by order it is 7/8/2025. Lordship, the respondent was directed to conduct an verification. Lordship, the verification was conducted. In the verification report is annexed in the state government affidavit.
Affidavit filed by the
State respondent.
that's page 11.
Page 11, Lordship.
In inviting so and so, we are hereby verification report of our visit in so and so. The self verification, it is learned from the up to the death of so and so, that elder son of so and so, his younger brother so and so was crowned in the arm and so and so, so and so. Like upon both the parties that in terms of the mutual for making appointment to the hierarchy state of so and so. Hierarchy used to be a sum of which will be on with the land and so as tells us we will live permanently that Mr. Council. But this report is submitted on 11/9.
Yes, Lordship.
So it says that you don't go for appointment as per land ownership.
Lordship, as per the last paragraph, that is the Lordship. But Lordship, if you see the report, Lordship, in the
Page 12, page
yes,
12,
page 12.
last line.
Lordship, if
With
you
all
see-
the report being stated, it will be relevant on the part of the directorate of so and so if the appointment is processed on merit basis.
Yes.
Then
Lordship, it's a verification report at the last paragraph in the page 11 from it starts.
yes,
It was also raised, Lordship. It was also raised and agreed upon by both parties that on the terms of mutual agreement for making appointment to Kang Yuk instead of Ingang Wang. Kang Yuk used to be a sum of rupees 2,000 to Ingang Wang as monthly basis out of the salary he received. Lordship, the private respondent is the son of Kang Yuk.
of
The private respondent is a son of Kang Yuk.
ah,
So in lieu of his appointment, he's paying an amount of rupees 2,000 to Ingang Wang. And Ingang Wang is the petitioner's father brother. That means petitioner's uncle.
father, brother. Okay, then
Worship, yes. However, the question be on who. This is very important. The next slide. However, the question be on who acquired the land. The lineage of inheritance lies the supremacy on land middle, which still us vividly from the family trees that Mr. Kang, that is a petitioner, sits in the apex precedence of Ang from the ancestral lineage, and therefore he enjoys the rightful honor on land matters, including the portion of the land on dispute. So as per this report, the petitioner is the landowner.
who?
And the worship
Petitioner's uncle.
no petitioner.
Petitioner or
When
petitioner?
petitioner uncle, he also holds the right. Automatic the petitioner.
But why did your petitioner uncle take 2,000 rupees from the
Maybe that is the internal arrangement
That
between
is
the
disputed. That is not our version. That was submitted by the petitioner during the meeting. I was informed like
Worship in the cases. If
that is not our submission,
worship,
and we dispute that. We have not been.
First, the issue is if the petitioner is claiming to be appointed on landowner, his vacancy arose due to the retirement of his father.
Your father was appointed. Is
My-
it your father who was appointed?
Yes, my father, but he was not appointed on landowner. It was an irregular appointment.
Irregular appointment.
Lordship.
How did
Not,
you
not
become
on land
regular?
ownership basis.
Huh?
Not on land ownership basis.
You were not confirmed. Your father was confirmed or not?
Yes,
He was a confirmed employee.
Then how did you get confirmed if he was irregular?
Lordship, that was long back. He was confirmed.
Now, was it confirmed as regularization or on land ownership basis?
Initially was not appointed on a regular basis.
Hmm?
I was informed he was not appointed on a regular basis, but he was not appointed on land ownership basis.
Your Lordship, if we say again the second last line,
Petitioner also stated that in their petition that no one is appointed.
page 11, Lordship. Lordship, during the inquiry, the claim of the petition that was refuted by the present petition, the claim of the private
Any
respondent.
claim
Then
for
by majority
providing
vote, it
employment
appears
as a
in
result of oral, the department shall refer the matter to the department of your concern, who shall examine such claim carefully, including a so and so. So and so, that is the government official of Iman, and the Iman, in the time of oil, should be taken into interpretation. That it is not the policy to provide employment to the enemy in perpetuity that are permitted by variable and was appointed at the- So your case is, yes, your father was, but he was not appointed on land ownership.
No, Lordship. Even petitioner has stated that in their petition that no one is appointed.
Where is that? That is the only sentence we require for dismissal of the petition.
Lordship. Lordship, may I, kindly get the paragraph number 9, page number 7.
He is the rightful landowner of the land where the present so and so was constructed here. The said land, but the land was donated to the department. Oral agreement in so and so. Therefore, as per the land policy entitled to. Then where?
By 11, that is 5th line, 6th line, Your Lordship. However, till date, the department has not appointed.
Paragraph.
Paragraph 11.
That has not appointed any member from his family.
from my family, Lordship.
Lordship, the land belongs to my father. I have to inherit it.
Here the petitioner has not stated that from your family. His father donated with an oral agreement with the responding authorities that his family member will be appointed to grade 4 as and when required. However, till date, the department has not appointed any member from his family under Iman. As such, the impugned approval letter dated so and so are liable to be quashed. Now, let us see the affidavit of the respondents. Where is it? Yes, madam.
Well, Lordship, in the rejection report, if it says
Wait. Let us see affidavit filed by the respondent.
Lordship, simply next the rejection report only. No specific statement.
In the last paragraph of the report, it was also raised so and so. Huh? What is your stand?
Nothing, Lordship, only a rejection report.
Madam, what is this?
I need to
Why on
people
earth
in the
have,
middle.
no, madam, the question is very simple. Why have you appointed the respondent number 4 on land ownership basis? Why? These are answers which require next week.
Lordship.
Next week, I want an affidavit or an instruction. I'm putting it down. First, where there's no quarrel that the respondent number 4 was appointed on land ownership basis. There's no quarrel. So the first is, did you carry out any verification as regards the respondent number 4's right to be appointed on the land ownership basis? 1. Secondly, whether the respondent number 4's father was appointed on land ownership basis. These are the 2 things we require by way of instructions. Or otherwise, we will see the face of the additional chief secretary or whoever it is. Okay? Shut up. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Miss So-and-so, who appears on behalf of the respondent, state as well as Mr. So-and-so, who appears on behalf of the private respondent number 4. The petitioner herein have challenged the appointment of the respondent number 4 on land ownership basis on the ground that the respondent number 4 could not have been appointed on land ownership basis, as the land upon which the what center is that?
It should be Shinha Mokok Subcenter.
Sengha Mokok Subcenter was established is the land belonging to the petitioner's family. It is also the case of the petitioner that the said appointment has not been made in favor of the respondent number 4 by following the notification dated 5/3/2018, which requires the deputy commissioner to submit a report when a case of oral agreement is set up by a candidate claiming appointment on land ownership basis. It is also mentioned that even otherwise, also even assuming for argument's sake, the land belongs to the father of the petitioner, belongs to the respondent number 4, without admitting, then also the father of the petition respondent number 4 was appointed on land ownership basis, and as such, in terms with the notification dated 5/3/2018, as it is the policy of the state that appointment on land ownership basis cannot be done in perpetuity, the consideration of the respondent number 4 for appointment on land ownership basis and appointing the respondent number 4 is contrary to the provisions of is contrary to the policy of the state. Taking into account the said submissions made by Mr. Limpong, the learned counsel appearing on behalf of the petitioner, this court, taking into account that no affidavit has been filed by the respondents, seeks the following instructions to be placed positively on the next date. Number 1, whether any verification was conducted by the respondent authorities in terms with clause 3 of the office memorandum of the notification dated 5/3/2018, whereby it was recommended that the petitioner, the respondent number 4, was entitled to be appointed on land ownership basis on the ground that the land for setting up of the Singa Mokok Subcenter was established on land donated by the respondent number 4's family pursuant to oral agreement. Number 2, whether the father of the respondent number 4 was appointed on land ownership basis, or was the appointment of the respondent number 4's father was for other on land ownership basis. This the matter. Next, we get the instruction on 24th. This is the matter on 24th of March 2026 for producing the instructions.
for admission. Item number 6.
May I please, Your Lordship?
Yes.
Your Lordship, this matter is with regard to termination of petitioner's service. She was terminated on the basis of the cabinet's decision, Your Lordship.
Why?
The cabinet's, because Your Lordship, the petitioner's data on the PIMS portal and the records did not tally. And she was asked, she did not submit any applications regarding the rectification. No documents were received from the petitioner, Your Lordship. So basing on that, Cabinet's decision of termination of 1,309 work charge employees in PWD department, petitioner was one among them, Your Lordship.
Six 2024. Let's see which the document. Where is the document? Impugned document, Mr. Counsel?
Your Lordship, I may be allowed to advise this. Your Lordship, initially I was appointed under category B. However, in my termination, it was mentioned under category N. And it was terminated on the basis of the wrong entry of my initial letter.
And when were you appointed?
Your Lordship, I was appointed in the year 1994. Next year.
What is the name of the petitioner? You were asked to submit this so cause.
Annexure 1, page number 27.
You were asked to submit the Aadhaar card, birth certificate, and appointment letter.
Your Lordship, I have filed my reply in affidavit on the last occasion.
No, it's okay.
Yes.
My
yes.
question is,
Yes.
page 54 is Annexure 18. These are the documents you have submitted.
Yes, sir.
Okay. Now let's see the show cause. What was it? Prayer for forwarding here. Where's your show cause which is being asked? You are challenging.
Show cause annexure 21.
And where's the cabinet's decision?
Your Lordship, Cabinet's decision is at page 26, annexure
Of your
this affidavit in opposition.
6. Now, this is a approval. Termination form service in respect to 1309 work charge employees. This is approved. Why was it terminated? What was the reason behind this?
Your Lordship, before termination was done,
Ah.
show cause notice was issued, and then the petitioner filed his reply to the.
Where is the show cause notice?
Annexure 21, Your Lordship. Annexure 21, page 58.
Whereas in pursuance to the approval of the covenant and so, unless he giving you notice for termination of which was the behavior was found to be irregular and falls under N category. What is N subcategory?
Your Lordship, here, data of the petitioner does not, in the PIMS portal, it does not tally
So-
with the
So
record.
prior to that, how did you form the N subcategory? My question.
Initially, Your Lordship, verification was done in 2020-21. At that time, he was under B category, and then he was also asked to submit the relevant documents because it does not tally. The date of appointment also was different. His name, the petitioner's name, date of birth, all these were incorrect. But apart from that, no application came forward from the petitioner, no documents came forward. Then after that, in 2022, again, another verification was done by the department. At that time, he was placed in N category, Your Lordship.
Now my question is, how did you have this N category?
Your Lordship, for that, I have to get instructions.
Earlier, it was the petitioner was B category. What is
Yes,
B
sir.
category? What is the name of the petitioner? Mr. Counsel?
Sunung Tikir.
Wensang Tikir.
Yes, sir.
Wensang Tikir is where? At page 44, his name is there. No. Here. There it is. Wensang Tikir. Wensang Tikir.
Page 46, Your Lordship.
Date of birth in Aadhaar.
Serial number 10.
Same. April. Then father's name. Then so this is the page 46 is the discrepancy.
Yes, Your Lordship.
What
Under
that
the-
you are going to
Yes,
terminate?
Your Lordship. I was terminated on the basis of the made an error by the PIMS.
Your
Is it-
Lordship,
is it-
ample of time was given, Your Lordship.
No. The thing is, did you have the option of correcting it?
That's why, Your
You
Lordship.
see, I understand. His date of birth in Aadhaar was shown as 4th of March 1973. But his date of birth in other papers, which is given out here, is shown as 4th of April, 6th of April 1973. Aadhaar came later on. So there is another date of birth. But that Aadhaar, one has to understand that Aadhaar is nothing to do with the date of birth. It is only to show what is the that he's not even a citizen of India, that he belongs to the Indian land. He's an Indian. That's all. Citizen of India is also not taken into consideration on the basis of the Aadhaar. Date of birth cannot be looked on the basis of the Aadhaar. These are things which is settled by Supreme Court. Then the father, his name is Tongmung, and here in Aadhaar it is mentioned as Tomusu. The father also does not become on the basis of the Aadhaar. So under what circumstances you have done it?
So, Your Lordship, to rectify this,
You should have given an opportunity, a person who has been working from 1994.
Yes, Your Lordship. And I've
It is
been
not done. If this is the ground on which you have dismissed it on this is at page 46, then I think this is high time we need to interfere with this. A person who has been working from 1994 in 2000,
in 2008, I was given a short course notice.
now you were terminated in 2024, 22,
24.
24. After working for 30 years, when his right came for regularization, you terminated.
Yes.
This is not a thing which can be done.
But Your Lordship, ample of time was given to rectify this mistake, Your Lordship. He never
Rectify where?
submitted any documents.
When did you give
I
that?
have stated in my affidavit also.
So let us see your where it is.
Your Lordship, in paragraph 4, page 3, the second paragraph. Furthermore, it is the duty of every individual employee to write an application enclosing the required necessary documents to the concerned authority stating that there are discrepancy needs to be corrected in the PIMS, and the concerned department forwards the same to the PNR department. Thereafter, if the PNR is satisfied with the documents of the individual, rectification is done. However, in the case of the petitioner, no such application. is
And what is the work the petitioner does?
Your Lordship, show cause notice was served
Mr. Counsel, come to the point. What do you do? You were employed as what?
as a under B category as gardener.
Mali, Your Lordship, yes, Mali.
Mali.
Yes, ma'am.
How will a Mali know what to do? Did you issue him a notice to the effect that, look here, you do it? You have put him in some N category. You have issued him a show cause, which is difficult for you and me also to understand what do you mean by N category and what is the basis on which you have formed the N category. So this type of appointment has to be interfered with. We are not touching on the cabinet decision, what they have done, because the cabinet decision otherwise does not speak. You ought to have enclosed the cabinet memorandum on which a decision has come. You have not enclosed the cabinet memorandum. But the fact that the discrepancy, yes, this is something, he is asking that my date of birth is 6th of April 2023. Now, what are you doing? You are saying that you have put some wrong name out there in your Aadhaar. Because Aadhaar comes later on. So are you going to terminate somebody because of the wrong name put in the Aadhaar? That is what has happened. Can you do that? You cannot. I formulate the point.
Yes.
Next time you argue before another judge. Simple point. This is it. Or if you want to argue next week, fantastic.
Your Lordship, in fact, show cause notice was served.
No, this so-called notice, for you also as a lawyer, it is difficult to understand. For a judge, I have difficulty to understand as to how do you formulate what is an N category. They say that you have been put at an N category. Where is it mentioned that these are the circumstances on which a person will fall in an N category? The so-called notice also is very vague.
Yes, Your Lordship.
And based on what you have mentioned in the Aadhaar cannot be a ground for dismissing him. He should be given an opportunity to correct. If he wants that, what the Nagaland government appears to be doing is that those persons concerned who are there, they should be their data, their service books should align with the Aadhaar card. And if you don't, align with the Aadhaar card which is made subsequently, which may be wrong or right or whatever may be, you terminate him. Is it reasonable, madam? You think about it. We have it next week. I formulate this point.
Yes, Your Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. A.M.E. appears on behalf of the state respondents. The petitioner herein have assailed the termination of the petitioner, have assailed the show cause notice dated so-and-so, Salu, as well as the termination of the petitioner on so-and-so. This court, upon perusal of the materials and records, finds it relevant to observe that the termination of the petitioner is based upon certain discrepancies of the petitioner's service book maintained by the department with that of the Aadhaar card, which was much subsequently made, taking into account that the petitioner was appointed as far back as in the year 1994.
Your Lordship, discrepancies were in the PIMS portal, not the service
Yes.
book. PIMS portal.
PIMS portal. PIMS portal is based upon service book. It has to be, something has to be there from the service records. Discrepancy in the service records of the petitioner with that of the Aadhaar card which was prepared subsequent. This court duly takes note of the submission of Miss AME, the learned counsel appearing on behalf of the petitioner, a respondent, that the discrepancy is based upon is in the PIMS portal vis-a-vis the Aadhaar, the records, the Aadhaar card of the petitioner. This court made a specific query as to on what basis the PIMS portal, the records of on what basis the inputs are made in the PIMS portal. Ms. AMS, with due fairness, submits that the same is being done on the basis of the petitioner's service records. This court further takes note of the discrepancy on the basis of which the petitioner was terminated. In the PIMS portal, EIIMS, PIMS portal, the petitioner's name was mentioned as Tuan Sang Tikir, TSUSANG TIKHIR. And in the Aadhaar card, it is mentioned as Tun Sung Tikir, TSUNONG Tikir. In the PIMS portal, the petitioner's date of birth is mentioned as 6th April 1973, whereas in the Aadhaar card, it is mentioned as 4th March 1973. The petitioner's father's name in the PIMS portal is mentioned as Tongmung, TONGMONG, whereas in the Aadhaar card, it is mentioned as Tomusu, TOMUSU. The question, however, arises as to whether the Aadhaar card can be made the basis for the purpose of taking on record, for the purpose of the name of the father, the date of birth, as well as the name of the petitioner. Or for that matter, can on the basis of there being a discrepancy between the PIMS portal and the details incorporated in the Aadhaar card, a person can be dismissed. It prima facie appears before this court that on these grounds, a person cannot be dismissed, taking into account that the details of the Aadhaar card can be very well rectified. And same is the case of the PIMS portal. This court cannot also turn a blind eye to the fact that the petitioner herein was appointed in the year 1994. And the petitioner is working as a Mali bracket gardener, which is a grade 4 post. This court also takes note of the show cause notice which was issued to the petitioner, which is impugned in the instant proceedings. The contents of the said show cause notice are vague and in as much as there is no explanation as to what does N category mean. Considering the above, this court fixes this matter again on 24th of March 2026 for hearing Full stop. Miss AMA shall obtain the necessary instructions. Shall obtain the necessary instructions on that said aspect, or on the aforesaid aspect, and place the matter before the court, and place the same before. You find out there are judgments to the effect, what is Aadhaar card?
Yes. Much.
For admission, item number 7.
Your Lordship, on behalf of my colleague Inaholi, Your Lordship, if this matter can be taken up on Thursday. She had some medical emergency today, Your Lordship.
You are receiving the salary, madam?
Lordship, the petitioners have not received their salary till date.
My goodness. From 2021,
Yes, Lordship.
and government has not filed affidavit.
Your
How
Lordship,
will
on
they
the-
survive? And what do you do?
Lordship, I'm appointed as work judge, neighbor.
Work charge leave. And you are working? No. Obviously. How can you work? The grievance of the petitioner herein is that the petitioner have not received the salary from the month of July 2021, for which the petitioner have filed the instant petition. The record reveals that notice was issued by this court as far back as on 4/8/2025. Till date, the respondents have not placed any till date, not to speak of filing an affidavit by the respondents, instructions have not been placed. Taking into account the above, this court fixes the matter on 23/2026, on which date the respondents shall produce the instructions as to why the petitioner have not been paid the salary. Failure to do so, this court shall be constrained to pass appropriate directions.
For admission, item number 8.
Lordship, sempre.
Same.
Much obliged.
For admission, item number 10.
Lordship, here, the petitioner's case is under process, Lordship. The petitioner's case is under process
What case?
for regularization, Lordship.
How many years? 30 years complete.
Lordship.
Ms. S. Chang, the learned counsel appearing on behalf of the state respondent, submits that taking into account that the petitioner had completed 30 years of service and have been appointed on the scale of pay, the petitioner's case is under active consideration before the government in terms with the office memorandum dated 17/3/2015. Pusto. Taking into account the above, list this matter again on 24/2026 for an update.
For admission, item number 11.
Bless your Lordship. Lordship, on behalf of LB Santa Medicinality, state is due to fund. So if 3 weeks time, we can for that, Lordship.
What is the case?
Your Lordship, the
My
petitioner is Mason by profession, and then the petitioner has been directed by the Deputy Commissioner of Mokjong to stop quarrying activities on his own land.
My lord, we had constructed a transmission system. I'm for respondent 6 and 7 power grid, my lord. On top of one of the towers was placed on top of the hill. This transmission system was completed and has been transmitting since 2015, my lord. However, my lord, over the last year and a half, the petitioner here and have started, they were querying, and the advanced querying has happened at the foothill of the hillock on which the tower is placed, which will affect and has eventually affected the integrity of the tower. Accordingly, my lord,
Now,
we
now,
had
now,
written-
now, Mr. Khera,
my lord,
tell me one thing.
my lord,
You have taken the right of way, I suppose, under
my
the
lord,
transmission lines
my
in
lord,
that land.
my lord.
Where is your affidavit?
My lord, we have already filed an affidavit, my lord.
Where is it that you have taken the power, the right of way in that area?
My lord, it's specific in my affidavit, my lord. The annexure 1 is the gazetteer notification.
Yes.
And my lord, present scenario being the case, we are now taking the option, exploring the option of shifting this tower, my lord, because the base at the foothill has become weak. The petitioner, so as we stand today, my lord, the DC has stopped them from doing any querying activity as the tower might collapse. However, my lord, the issue which we are facing is that when we are contemplating upon shifting, we are the other landlords, the other on whose land the tower now will be proposed to be re-erected, my lord, and or shifted, my lord. We are having, they are doing a little bit of a, my lord, they're opposing it. So we are into for advanced stages of communication with them.
But
And
Mr. Khera, my question is very simple.
my lord,
Have you taken the right of way over the land where the petitioner has put up its query? My
my
question.
lord, my lord, petitioner's query was not on the land where we have put the tower. His query is at the foothill of the rock, my lord.
Understood. So, the fact that there is no right of yours over the petitioner's right to carry on a query.
My lord, the subsequent activity of the
Because of
petitioner,
the query, you are being affected long down. You are affected because you have put some transmission of tower
my
in
lord,
somebody's land where you have taken the right of way.
my lord,
Now, the petitioner, how can the petitioner's right, who has petitioner's right to carry out the query, the works of query can be stopped at your instance or at the instance of the deputy commissioner? Yes, temporarily, if you are shifting out there, it's a different aspect of the matter.
my lord. We
Otherwise,
are shifting, my lord.
then otherwise the petitioner would be at loss.
My lord, it has been our stand right from the day one. Petitioner is also aware that we are in the process of shifting, my lord.
You were in the process of shifting in the year 2025. We have now in the year 2026. 1 year has passed, isn't it?
My lord, page 20, para
The
5.1.
last order was passed on 18/5/2023, which is being challenged, which is 3 years from down the line. If you
My
are
lord.
in the process of shifting, you have to shift. Otherwise, pay compensation to the petitioner for the loss.
My lord, I may be given a week's time to file an affidavit on the present scenario. I have seek time on the last date. I have been incapacitated to file the affidavit. I'll require 1 week's time, and I'll come up and satisfy the query which my lord has also raised with regards to the right of way.
Heard Ms. Swansdown, the learned counsel appearing on behalf of the petitioner. Ms. Asang appears on behalf of the state respondents. Mr. Nitin Khera, learned counsel, who appears on behalf of the respondent number 6 and 7.
My lord.
The petitioner herein have assailed the order passed by the DC.
Pardon?
Who has passed that order?
By DC,
Deputy Commissioner Mukokchung, my lord.
By the DC Mokokchung, dated 18/5/2023, whereby the petitioner have been stopped for carrying out the querying activities. First, this court had put a pointed query upon Mr. N. Khera, the learned counsel appearing on behalf of the respondent number 6 and 7, as to whether any right to way have been taken over the land belonging to the petitioner. The learned counsel submits that the right to way have not been taken from the land as regards the land of the petitioner. However, the querying activities, if permitted to carry out, would result in weakening the structure in the nearby land wherein the respondent number 6 and 7 have erected the power transmission line. He, however, submits He, however, submits that there is a proposal going on for shifting of the power transmission line so that a transmission line, in view of the weakening of the base on account of the quarrying activities carried out by the petitioner. So in that regard, he submits that he will file an additional affidavit within a week's time. List this matter again on 26th of March 2026. Additional affidavit will be filed by 24th of March 2026.
My lord, if permitted to make one submission, my lord.
Please do.
My lord, also I may be in that affidavit, I'll also state with regards to the current status of taking the right of way over the land or not, my lord.
In addition to that, the petitioner, the respondent number 6 and 7 is also permitted to state as to whether the petitioner is taking any steps as to whether the respondent number 6 and 7 is taking any steps for taking the right of way over the land of the petitioner, isn't it?
My lord, if we have taken or not in the past, my lord.
As to whether
The first part may be corrected to that effect, my lord.
as to whether the petitioner have taken the right of way over the land of the petitioner. From the Mr. N. Khera submits that he is not certain as to whether the land of the petitioner, whether right to way over the land of the petitioner was taken. Line to last shall submit as to whether update and the petitioner is further. The respondent number 6 and 7 also in the additional affidavit shall state as to whether right of way over the petitioner's land was at all taken, at any stage taken.
Highly obliged, my lord.
Obliged, lordship.
My lord, permitted to leave, my lord.
Definitely, Mr. Khera.
Obliged, my lord.
For admission, item number 12.
What is this? All types of
Lordship, here I get to receive instructions, so if sometime we grant it, Lordship.
whole matter.
Lordship.
What is your case?
Lordship, both the petitioners, they've been retired from services without regularizing, Your Lordship.
Okay.
The petitioner one had been served for 23 years and the petitioner number 2, 33 years. On fixed
20?
pay, 23.
23, how do you get it?
Lordship,
How do you get regularized?
no, Lordship, yes, I'm not eligible as per the OM 2004 and 2015, but I have
You are not eligible as per 2005, 15.
4 and 15, Lordship.
Then
But Your Lordship, I have challenged some provisions of the State Office Memorandum, Your Lordship.
so I have already set aside those type of things. There was a challenge earlier. I have passed an order. You cannot challenge it.
No, Lordship, if I may, Your Lordship,
Bad case.
an appeal has been pending before the division bench, Your Lordship.
So what? The appeal has not set aside that judgment. I'm bound by my judgment.
If Lordship, in that case, Your Lordship, if my matter may become after the disposal of the appeal, Lordship, that will really. My matter may become after the disposal of the appeal, Your Lordship.
No, that case should be dismissed. Don't you think? The council appearing on behalf of the state respondent seeks a further 3 weeks' time for filing the affidavit. List this matter again on 11th of May 2026. A final opportunity given to the state respondents to bring on record the stand by filing the affidavit on or before 4th of May 2026.
Obliged, Lordship. For admission, item number 13.
Yes.
Lordship, here is the case of the petitioner is under process, Lordship.
Why? This is every time somebody is filing, I'm taking time. The petitioner starts and finishes off. Then with effect from so and so with all consequential and pensionary benefits. Now, what has happened, madam? What is your case?
Lordship, here we're seeking regularization under the OM data center.
Under the work charge.
Mr.
Work charge fixed labor so and so with scale. You were appointed when?
10
In the year
July
1994. you completed in the year 2024.
23.
How?
23, Lordship.
Okay, you were appointed in 1993. So you completed in the year 2023. Now you have not been regularized.
No, Lordship.
Okay, and 10-5, when did you retire?
0910
39. Okay, so 39 means you ought to have been, your case ought to have been taken into consideration in terms with clause 1, Roman 2 of the notification dated 17/3/2015. And the same being not done, you have approached this court.
So Lordship, the case of the petitioner is under process, Lordship.
Under process?
Yes, Lordship, so this matter can be disposed of.
Heard Ms. So the learned counsel appearing on behalf of the petitioner, Ms. Eshang appears on behalf of the state respondents. The petitioner herein was appointed on 10/5/1993 as a work charge, skilled labor at a fixed pay of ₹500 under the establishment of the Office of the Executive Engineer PhD. Thereupon, by an order dated 4/7/1994, the petitioner was granted the scale of pay, was promoted to the post of fitter helper and granted the scale of pay. The petitioner retired on 30/9/2023 and was expecting that the petitioner's case would be taken up for regularization as is the mandate in terms with clause 1, Roman 2 of the office memorandum dated 17/3/2015. The same having not been done, the petitioner has approached this court by filing the present petition. The learned counsel appearing on behalf of the state respondent submits that the case of the petitioner is under active consideration as the petitioner otherwise fulfills the mandate of having 30 years of service in the scale of pay. Considering the above, list this matter on 27th April 2026 for an update. This court observes that taking into account that the petitioner have retired in the year 2023, the respondent authorities are directed to take steps on keeping in mind that petitioner at present is not petitioner at present have crossed 63 years of age. The petitioner at present is a retired employee.
Okay.
For admission, item number 14.
May I please, Your Lordship? Lordship, I'm appearing for a petitioner in this matter. Lordship, at this stage, the affidavits of the state respondents are yet to be filed. So may I pray that the matter may be listed after the respective affidavits are filed, Lordship.
This is, you are asking for solatium.
Interest,
Under what provision?
Lordship, this in the earlier round of litigation, there was a PIL being filed. So in the
This acquisition is done under what provision?
there was a damage compensation being done, Lordship. This is regarding the damage compensation.
Done under what provision, Mr. Counsel?
This is not a land acquisition matter, Lordship.
Then?
This is damage compensation, Lordship. The
Then
assessment
how can you get solatium? How can you get solatium in interest? The entire petition is misconceived, isn't it, madam? Misconceived?
Lordship, as per the judgment in the PIL,
What? Which judgment?
judgment, as per PIL 9 of 2019, Lordship.
Where-
Judgment is at page number 657, Lordship.
What do you say?
In the judgment, it has been stated that the petitioners, as per the entitlement of the damage compensation, there was no dispute regarding the entitlement. So the court has said the petitioners have to be adequately compensated. But when the compensation amount was released from the sender, there was no component of interest included in after the assessment took place in 2016.
Mr. Counsel, it is a case out here that in 2012 there was something for which you are entitled for certain damages.
Lordship.
If you are entitled for certain damages, in fact, the court had been more here saying that, okay, you compute whatever amount you give it to them. You are not satisfied, you have to go before the civil court, not here under 226. We should dismiss your case. Why should we need the affidavit? Not necessary. Not necessary. See?
Lordship, I am being led by Senior Counsel Mr. C.C. Toto in this
Senior
matter,
counsel.
and today
Yes,
it was not a
counsel.
fixed matter, Lordship.
You tell
So-
you, Mr. Counsel, you should know that I don't grant accommodation for senior counsels.
I'm aware, Lordship. But
You-
today was not a fixed matter, Lordship, and
You practice.
I'm also a
Where
also
you
a-
practice, Mr. Counsel,
Lordship.
in the Kohima bench or in the principal seat?
I'm practicing principal seat, Lordship.
Then,
I seek apology, Lordship.
Mr. Counsel, you
It was-
know in my court, in the big TV,
Lordship, I'm aware.
number 2, no accommodation on the ground of senior counsel, it is mentioned.
Lordship, I'm aware.
So
I deeply apologize, Lordship, because it was
therefore,
not a
the
fixed
senior
matter, Lordship.
counsel not appearing is at his own peril. We should dismiss your petition.
It was not a fixed matter, Lordship. Today was not a fixed matter. That is why I'm praying for one accommodation,
Every
Lordship.
day,
Thank
you also know, whenever a matter comes up for admission before me, it is on that day, it's a most likelihood that the matter would get finished off.
Lordship, I'm aware of that.
So now we should dismiss your.
I'm just praying for one accommodation, Lordship, kindly.
Chalo. The counsel appearing on behalf of the petitioner. No, full stop. The instant petition has been filed by the petitioners seeking additional compensation in the form of solatium and interest. What is the prayer? Additional compensation
For a delayed payment, Lordship.
form of solatium and interest. This court inquired with the learned counsel appearing on behalf of the petitioner as to how the question of solatium or interest would arise in the present case, as it is not a case of land acquisition, rather a case where damages have been caused to the property of the petitioners on account of certain constructions being carried out by the state respondents, state or union, by the by the National Highway Authorities.
Lordship.
First, this court further put a query upon the learned counsel appearing on behalf of the petitioner as to whether the instant case would not be a case wherein the compensation so paid pursuant to the directions passed by this court in PIL number so and so.
9, Lordship.
PIL in the order dated so and so in PIL number so and so. Order dated
31, 2023.
31 2023 in PIL numbers.
PL number 9, Lordship.
PL number 9 oblique so and so.
2019.
And this court has put a query upon the counsel for the petitioner as to whether the instant case would not be a case wherein the petitioners are aggrieved by the inadequacy of the compensation. On account of on the inadequacy of the compensation, so granted to the petitioners pursuant to the order dated 31/2023 in PIL 9/2019. And if that be so, wouldn't that be a case falling strictly within the ambit falling within the and if that be the case, wouldn't the petitioner have to resort to remedies before the competent civil court of civil jurisdiction? The learned counsel submits that he would address this court on the next date. When do you want the dismissal?
Lordship, any day that after the affidavit, respective affidavits are filed, Lordship. I've been informed that they will be filing the affidavit.
No, they won't file a order. They are not going to file. No? They are not going to file. When? Next week? Let your senior come.
Lordship, any day after 3 weeks, Lordship.
No, I'm here only for 1 and 2 months next week. So we have it on 26th of March 2026. On 26th of March 2026. I know this type of matters, Mr. Counsel, why I am saying so, there is a specific reason.
Lordship.
Delay.
Lordship.
You see, what is it? Why I'm saying? Your cases does not come within the within the purview of the National Highways Act,
Lordship.
or under the Land Acquisition
LA Act.
Right to Fair Compensation Act.
Lordship.
Your case is a case where, on account of certain constructions being carried out, there's a damage being caused to you.
Lordship.
So you therefore would not come within the ambit of Section 23, Roman 1 to Roman 6 of the Land Acquisition Act, which is required to be taken in view of Section 3G7 of the National Highways Act 1.
Lordship.
You also do not come within the ambit of Section 24 to 30, 26 to 30, and more particularly 28 of the Right to Fair Compensation Act.
Lordship.
Then in that case, the question of getting solatium or interest, you are entitled to interest. There's no query. But your actual case is the compensations which have been given should have been much higher.
Lordship.
How will I look into that? The damage.
My case is a delayed payment, Lordship. The assessment took place in 2016, Lordship. And the judgment was of 2023 and the amount was paid to me only
No,
in
the
2024.
judgment was made in the year 2023 directing them to pay, but you have prayer for solatium. Are you going to give up that prayer for solatium? My question is this.
Lordship.
What will be your interest? Because your interest would not come under Section 9, under Section 34 or any other provisions. The interest will be not 9 or 15. Your interest will be as per the CPC, which will be 6%, or at best the commercial interest, which will be 7 or 8%. So therefore, these are questions which needs to be proved before a court of civil jurisdiction, which I think your senior would also think about it when he addresses me on 26th.
Lordship. Deeply obliged.
The supplementary cost list for admission, item number 31.
Yes.
Lordship, this is a problem case, my lord.
What is this?
Lordship, here the bank, the sole respondent, they have attached my pension, Lordship.
For not
Recovery.
payment.
Recovery of loan.
Rightly so.
Yes, which is not permissible.
Why?
Lordship. Firstly, Lordship, there is the legal power under section 60 of the Civil Procedure Code. Secondly, Lordship,
Section 60's bar is on the pension, not
Yes.
the moment it arrives to the bank account.
yes,
It is no longer pension.
no, Lordship,
Law is
no,
settled.
Lordship, I may be allowed to complete my submission, Lordship.
Please.
Here in Nagaland, Lordship, I'll go-
Nagaland, something else apply.
Yes,
What?
Lordship. Here, every government servant who draws salary from the state exchequer. What I want to say is that the loan is not linked to the bank account. Every government employee, they are required to open an account in the State Bank of India. And the amount, whether it is salary, whether it is pension, is paid through that account, Lordship. Now, Lordship, which is why after retirement, the pension has been paid to the petitioner, the pensioner, through that SBI account, Lordship. Secondly, Lordship, the agreement which they have annexed, the SBI.
That is not in Nagaland, in all cases.
My
it's the
lord,
same.
my lord,
Yeah.
my lord, my lord. In secondly, Lordship, the agreement which they have annexed, the SBI. Here, my client has given security, Lordship, a property. That, Lordship, they have, without trying to take possession of it or try to auction it, Lordship, by adopting legal recourse, Lordship, they have conveniently jumped on my pension. Wherein, Lordship, that is the sole, and they are deducting 100%, Lordship. Not even a single penny I am drawing. And Lordship, in the evening of my life, Lordship, I am also a handicapped person, Lordship, by birth. Earlier, for state employment, there was no handicap quota, Lordship, which is otherwise he would have been given employment under handicap quota, Lordship. Now, in the evening of my life, I am facing untold hardships. Now, Lordship, recently, the secured property, it has also been taken over by the bank.
Huh?
It has also been taken over by the bank. They have taken possession of the property, which Lordship is said the particulars of the property are given at page 28 of the affidavit filed by the sole respondent, the bank, Lordship.
Then,
I may be permitted to, Lordship.
affidavit?
Yes, filed by the bank, Lordship. Page 28. Point number 8, security. The loan will be
Page,
secured by
paragraph?
paragraph 8, my lord.
8.
Yes, my lord. Security. Page
Yes.
28. What I want to say, Lordship, is that there is adequate security, Lordship. The loan will be secured by so and so registered mortgage extension of mortgage of the land and building / flat situated at house number so and so.
Where?
Page 28, Lordship.
Of
the affidavit in opposition filed by the bank, Lordship.
Yes. Where?
Page 28, my lord.
Interest. Alright. You are referring to
Yes, paragraph 8 is security, Lordship.
8. Yes,
Yes,
sir.
Lordship.
The loan will be secured by equitable / registered mortgage extension of so and so or rupees so and so.
Yes, Lordship.
Equitable registered mortgage of so and so. Then
Now, Lordship, the petitioner, they have vacated the property. The bank has taken possession of the land and building. I believe at this market rate, Lordship, it will be worth more than 3 crores, Lordship. Here also they have said that it is worth 2 crores 28 lakhs something, Lordship. And they have worked out the outstanding.
so they have taken action under the surface. They have taken action under the surface side.
Lordship, I'm yet to get instruction on that, Lordship.
Oh,
Lordship, the standing counsel is Mr. YP Gupta, Lordship.
They have changed the standing counsel, Lordship. The bank, they have changed their standing counsel.
so
Now there is another counsel, Lordship. not my learned friend.
Mr. Sandianga not only comments on his case, he also comments on the appointment of the standing counsel. Then
I am sorry, my lord.
what
I was only trying to
what
assist
is
this
wrong
court.
with the order?
So, Lordship, the order, Lordship, is firstly against this.
But how do you know that they have taken the land?
No, Lordship, now I am staying in a rented place, Lordship.
So,
Which is why, Lordship, the point I want to make is, Lordship, the order
no.
attaching
No,
pension
Mr.
is firstly
Mr.
against the
Mr.
statutory
Mr.
provision.
Santiang.
Secondly, it is against
No,
the
Mr.
loan agreement.
No, Mr. Kindly listen. Possession over a particular property,
Yes, Lordship.
in the case of an equitable mortgage, can be normally taken by a decree of the court.
Lordship.
Or if a recovery proceedings is given in a DRT proceedings,
My lord.
and the DRT officer issues a certificate.
Lordship. Nothing as such was done.
Wait, let me complete.
My
Don't
lord,
be
my lord.
through here. The third is,
Yes,
when action is being taken
my lord.
under the surface side,
Yeah, Lord.
whereby, in terms with section 13(1), a notice would be issued
Lordship.
asking you to pay within 2 months
Yes,
this
Lord.
amount,
Lord.
or explain.
Yes, Lordship.
As per 13(4),
Yes.
they can take over the possession.
Yes, Lordship.
Have they done under 13(4)?
Lordship, they have given us some time, the outstanding, which is yet to lapse, is they have worked out at 35 lakhs, Lordship. The time that the bank has given to us, Lordship, it is yet to lapse. Now, if I am also trying to make arrangements, Lordship, to repay the amounts, since I don't want the bank to take over my property, Lordship, but that time period is yet to lapse. At this stage, that is the legal, that is the factual possession, Lordship. Which is why, Lordship,
Has the stay been vacated?
no.
We vacate the stay.
No, Lordship.
Yes.
No, Lordship. It will be, Lordship, on the date of the decision passed by the Honorable Supreme Court in Rakesh Gupta's case, Lordship.
What does he say?
I have given the book list, Lordship. Okay, 2009, 1 SCC, Lordship, 376.
Yes.
There is another decision, Lordship, passed by this Honorable Court, Lordship, reported in 2016 to GLR, Lordship. But
Okay.
before I come to that, Lordship, I may be permitted to take my Lord to the Supreme Court decision in Rakesh Gupta, Lordship, paragraph 33. However, we are also of the view that having regard to provisos G to section 61 of the Code, the High Court committed a jurisdictional error in directing that a portion of the decretal amount be satisfied from the fixed deposit receipts of the appellant held by the bank. The High Court also erred in placing the onus on the appellant to produce the matter in question for being auctioned for recovery of the decretal dues. In other words, the High Court erred in altering the decree of the trial court in its revisional jurisdiction, particularly when the pension and gratuity of the appellant, which had been converted into fixed deposits, could not be attached under the provisions of the Code of Civil Procedure. The decision in Jyoti Chit Fund case has been considerably watered down by later decisions which have been indicated in paragraph 22 herein before, and it has been held that the gratuity payable would not be liable to attachment for satisfaction of a court decree in view of proviso G to section 61 of the Code. My Lord, paragraph 37. Next page. In our view, instead of disturbing the order of the executing court, which was passed in consonance with the provisions of the Code of Civil Procedure, the High Court should have directed the respondent bank and the executing court to seriously pursue the recovery of the matato or proceed against any other property of the principal debtor having particular regard to the finding of the executing court that the said fixed deposits represented the retired benefits of the appellant. So, Lordship, the bank may, Lordship, as per the loan agreement, may proceed against the property.
So what?
But, Lordship, the pension.
Pension? The moment the pension is okay. The moment it reaches it doesn't know whether it is 57,000, whether it is this or that. So it becomes the state board. Okay.
Lordship, again in 2016 2 GLR 666, Lordship.
Yes.
Paragraph 18 and 20, Lordship, I may be permitted to read. In the instant case, the action of the respondent bank in the direction of depriving the petitioner of his property do not emanate from any statutory law, rules, or regulations empowering the bank to do so. The reliance placed by Mr. Chamaria under the circular dated so-and-so is of no legal assistance, as it is not clothed by any statutory power/authority. It is merely an executive fiat that cannot be enforced for the purpose which is the subject matter of the challenge hearing. Turning into the provisions under the Code of Civil Procedure, particularly the proviso G to section 61 thereof, it restricts attachment of stipend and gratuities allowed to pensioners of the government or of a local authority or of any other employees, even in extreme cases where a decree is put to execution. The proviso G to section 60 subclass 1 of the Code of Civil Procedure has also received interpretation of the apex court in the case of so-and-so to mean pension and gratuity which had been converted into fixed deposits. Also, pension and gratuity received by way of retirement benefits continue to be covered by proviso G to section 61 of the Code of Civil Procedure, even at the cost of repetition. It is observed that the statement made by the petitioner on oath that out of the terminal benefits received on superannuation from service, a sum of rupees 10 lakhs has been invested by way of fixed deposit. The same has not stood controverted by the respondent bank. Lordship, here also, Lordship, the amount was deposited in the bank as fixed deposit, Lordship.
So what?
Now, Lordship, this honorable court has held that no, since it is pension, Lordship,
Go to
that
Supreme
amount.
Go to Supreme Court also. This is the order which I am going to pass.
Now, Lordship,
Once it receives, comes and
what
returns,
cannot be done directly cannot also be done indirectly, Lordship.
that can be done very well. You have taken a loan. You are not filling up the installments. So what will the state bank do? This is after all
They
public
can
money.
proceed against my property, Lordship.
The property is difficult. There are
No, why
many
not?
aspects
Why not,
of
Lord,
a property.
Lordship? There are so many defaulters, Lordship, because I am not the first person to default loan, Lordship, in the state of Nagaland. There are so many other similar.
Mr. Sandingra, mercy is just outside the door. I am here, no mercy. I don't have mercy.
Lordship,
The law
I am only saying
categorically
that
says.
the law does not permit, Lordship.
No.
Also, Lordship, the agreement, Lordship, the agreement clearly stipulates that, clearly provides in clause 8, the security that I have deposited before the bank. I have given my pata, Lordship, in original, Lordship. It is with the bank, those documents. Now, which is why I have been told to vacate the building premises. I have done so, Lordship. It is not that I am not in a position to repair. This property can very well be auctioned. But what I am saying is that, Lordship, pension is for survival. We have even requested the bank to deduct 50% and leave some amount to us so that I will be able to take care of my ill health. That also they refuse. Only after making such fervent requests, Lordship, on 4 or 5 occasions, we have approached this honorable court. Very reluctantly, my lord. Because, Lordship, as my lord has pointed out, we also don't want to spoil the good terms with the bank, Lordship, which is why we waited, Lordship. Only as a last resort, we have approached this honorable court, Lordship.
We cannot.
Now, my Lord is very well aware of the provision of law, Lordship. There is clear statutory power under Section 60, subclause 1,
That shall not apply.
subclause G, Lordship.
That shall not apply. Now, are you operating the bank account or not?
Yes, Lordship.
You are operating.
Yes, Lordship.
And
Lordship, that account has not been freezed, Lordship. And Lordship, besides my monthly pension, there is no other income, Lordship.
so,
Which
so
I'm
it is
using,
very good.
Lordship.
Once you are about to retire, you take a loan and then say that I am not going to pay.
No,
Monthly
Lordship,
pension
Lordship,
is over.
Lordship,
You cannot.
if there was no property security, then, or if there was no calendar, then that is a problem, Lordship. The banks, they are also wise, Lordship. The bank is also wise, Lordship, and they have taken adequate security. It is just that, Lordship, they have, without trying to enforce the loan agreement, they have conveniently jumped on my family pension, on my pension. And that too, Lordship, they are deducting 100%.
How much is your pension?
A little more than 50,000, Lordship.
Okay. You
And
take the 49,231 from the bank account. That is the installment, huh?
No, Lordship.
Yes.
Lordship, the law says that, Lordship,
Division bench?
my Lord, then in that case, Lordship, in that case, it may be taken up on Tuesday, and because since my Lord will be sitting next week also,
Huh?
since my Lord will be sitting next week also, Lordship, if it can be taken up next week, Lordship, so that if I have to approach the division bench, Lordship.
So, division bench, when you approach is your time.
No, my Lord,
You
Lordship,
can approach.
there is urgency, Lordship.
There's no urgency.
Lord, there is urgency, Lordship,
No.
which is why, Lordship, if I have to approach the division bench, Lordship, at least I will have that window, Lordship.
No window.
Because, Lordship, the next DB, it will come only, Lordship, after next week, which is why,
So?
Lordship.
The law is very well settled. We dismiss your petition right away. 2 o'clock, we dismiss. There
No,
are 2
Lordship,
other matters.
what I'm saying is, Lordship,
Dismiss.
what I am requesting is, Lordship, if it can be listed Monday or Tuesday, Lordship. I know my Lord has already spoken your mind, Lordship.
I'll dismiss it right
So that,
away.
yes,
No,
so that, Lordship,
I gave the time yesterday only. When the matter came up, I fixed it today
yes, Lordship.
to dismiss it.
Then, Lordship, in that case, Lordship,
Yeah.
my submissions may kindly be recorded,
Oh, definitely.
Lordship.
Why won't I record it?
Lordship. And that, Lordship, and that the fact that, Lordship, that my account, Lordship, my pension account was never linked to was kept as a security to the loan, Lordship. And that, Lordship, in the state of Nagaland, or like perhaps in the state of Assam, all government servants who draw salary or pension from the state exchequer, they are required to open a bank account in the State Bank of India. And that, Lordship, just because of that, no longer the employees draws their salary in cash. It comes directly to their bank account, Lordship. And that is how, Lordship, I have no say in it, Lordship. That is what I want to say. The salary or pension is directly credited into my bank account, Lordship. It is not that I'm voluntarily depositing, Lordship. That if
you had
if
voluntarily,
my lords,
if you had the opportunity to do so voluntarily, you would never have deposited at all. Huh?
that Lordship, that will depend, Lordship. If after taking care of my health, Lordship, if after maintaining myself, if any amount remains, then I'll surely deposit, Lordship.
When is Mr. YP Gupta appearing?
Lordship, he was supposed to come today, Lordship, but he had some difficulty. If it can be fixed on Thursday, Lordship.
Okay, we'll have it on
On
Thursday.
Lordship.
Thursday.
Lordship.
It is not as per you, Mr. Santiago.
Lordship.
It is absolutely within the domain of the court to fix a date.
My lord, I am merely requesting,
And I'm
Lordship.
only asking him,
My
not
lord.
you.
My lord.
Making it very clear.
My lord, my
You
lord.
don't
my
say
lord.
when I am to fix the date.
My lord, my lord.
We have it on Thursday. Get your instructions as to whether any surfacing proceedings have been
Lord.
initiated as regards the petitioner's house.
Lord.
Mr. S. Santiago, the learned counsel appearing on behalf of the petitioner, submits that though there is a stay operating in the instant proceedings insofar as the bank account of the petitioner, but in the meantime, the respondent authorities have already taken possession of the petitioner's house, wherein there was an equitable mortgage created in terms with the loan agreement. However, nothing in that regard has been brought on record by filing an affidavit by the petitioners. Be that as it may, the counsel on behalf of the SBI is not present today. For considering the above, list this matter on Thursday, on which date the counsel appearing on behalf of the SBI shall apprise this court as to whether any proceedings have been initiated, thereby taking over the possession of the petitioner's house, which had been, in respect to which equitable mortgage had been created, and if so taken, under what provision of law. Full stop. Mr. Muajumi, who appears on behalf of who appears as a proxy counsel to Mr. YP Gupta, shall duly inform about the queries so raised by this court. List this matter on Thursday.
Lordship, let the interim continue to finish.
Absolutely no. I'm not going to continue. Interim.
For admission, item number 2.
What happened to senior? Senior, what happened? No senior.
Oh, he's in Dimapur. So it will be.
Video conferencing. Video conferencing.
His instruction to me is to pass over, no pass over to Monday. Which has difficulties.
Thursday.
He is not in, will not be in station.
Thursday.
Monday, Lord.
No. Ask him to do by video conferencing.
He'll be out of station.
He'll be in Dimapur.
No, he will not be in Dimapur.
Where?
He'll be in Zulunagar.
Oh, fantastic.
He'll be back Thursday evening. So
Can't help you anymore. I think we close it. We'll close it. Or we have it on Thursday, you prepare anything. You've got my point.
Okay.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the state respondents. And what is his name? Another person
Tushilungo
who
Lordship.
appears for respondent number
Lordship
4.
together.
Respondent number 5.
Lordship.
The materials and records show that the Office of the Deputy Commissioner, HIFRI, had issued an advertisement.
Lordship, the fact is that I have not applied based on the advertisement. I have submitted an application prior to the advertisement.
What is that admit card
They sent me based on my application.
to apply?
I have applied prior to the advertisement.
For land ownership, it is not there. For land ownership, there is no selection held.
Lordship, I did not apply based on the.
But you have not challenged the advertisement.
No, I have not been invited.
Understood. But you have not challenged the advertisement. Have you challenged the advertisement?
No, Lordship.
The materials
No,
will
Lordship,
report that the Office of the Deputy Commissioner, HIFRI,
Lordship, like.
have issued an advertisement on, what is the date of the advertisement?
August 2023.
On 9th of August 2023 for filling up of 3 posts of multitasking staff district under the district administration KIFRI. In pursuance thereto, the respondent number 5 along with 2 others were appointed. The petitioner claims ownership on the basis of land, claims appointment on land ownership basis. And it is the claim of the petitioner that the petitioner did not participate in pursuance to the said advertisement. It is also the case of the petitioner that the petitioner is entitled to land ownership basis in as much as the person concerned, in as much as the vacancy in respect to which the respondent number 5 was appointed should have been filled up by way of land on the basis of land ownership. Be that as it may, the petitioner have not challenged the advertisement. And the respondent number 5, along with 2 others, have been appointed on the basis of the advertisement on merit. The question arises that without a challenge to the advertisement, can the petitioner herein challenge the appointment of the respondent number 5 which was held, well, who was appointed in pursuance to the advertisement on the basis of determination on merit. Mr. So-and-so, appearing on behalf of the petitioner, submits that he needs some time in that regard. Lists the matter on Monday for final disposal.
Your Lordship, let's.
For orders, item number 15.
Dear Blessed Lordship. My Lord, this matter relates to reservation of seats for 7 backward tribes in the Eastern Nagaland, Lordship. In short, we term it as Eastern Nagaland.
Review is not there, no?
No, we have withdrawn.
Why the order matter has come up for orders?
This Honorable Court passed an order on page 18.
Yes.
This is the first order, Lordship. Paragraph 11, 12, and 13.
That's okay. I'm not on that. The question is why the matter has come up for orders.
By order dated 8/11/2023, that is the first date, we were directed to implement 6 tribes as respondents.
No, the matter has come that you have wanted to file a reply to the affidavit you have not filed.
If necessary, we wanted to file, but
You
on
don't want
going
to
through the
file.
affidavit, mostly some technical points have
So
been
you
raised.
don't want to file.
Yes.
Mr. C.T. Jamid, the learned counsel, senior counsel appearing on behalf of the petitioner, submits that upon instructions being taken from the respondent, from the petitioner, the petitioners are not inclined to file any affidavit in reply. Taking into account the above, list the matter for admission in the next week. Fix and give a date, huh?
For orders, item number 16.
Lordship, in compliance to this order dated 4/3/2026, I have published the notice on 2 local dailies of point circulation in the state of Nagaland, Lordship. I have annexed the newspapers as well, Lordship, on 4th of March, Lordship.
What is the matter about?
Lordship, it regards to land ownership appointment, Lordship. The private respondent, he has been approved to be appointed without any selection process. He is not also a landowner, Lordship. Whereas I have made an application, Lordship, and I have, my family, we have never claimed appointment on land ownership basis. the department is yet to file the affidavit. But I'm optimistic that the department will also agree to my stand, Lordship, that I have taken in my writ petition that none of my family members have been appointed on land ownership. That's still that, Lordship.
Okay. Private respondent is working under you?
Lordship.
Is the private respondent number 7 working under you? Is there a stay?
Yes, there is a stay, Lordship. Approval has been accorded, but prior to the issuance of the appointment order, my lord, we have approached this honorable court. The approval has been stayed by this court.
So no, respondent number 7 have not been appointed.
Yes, not yet been appointed, Your Lordship.
Mixer 9. Mixer 9, 7. Page 45.
In pursuance to the order passed by this court on 13/2/2026, you have made a paper publication of
Yes, my lord. I have filed affidavit to that effect as well, my lord.
the steps have been taken by the petitioner by carrying out paper publication. And in that regard, an affidavit has been filed on 13/3/2026.
Well,
Taking into account the above, this court deems that the service upon the respondent number 7 is complete. Accordingly, lists the matter for admission on 4th of May 2026. A final opportunity given to the respondent state to all the respondents to bring on record the stand by filing the affidavits on or before 27th of April 2026. First, liberty given to the petitioner to file reply thereagainst on or before the next date. First, the interim order passed earlier shall continue till the next date,
Lordship, the next date is
4th of May.
my lord.
Lordship.
If Lordship, if it can be earlier,
No, let them file the affidavit.
my lord, deeply obliged, my lord.
For orders, item number 17.
Yes.
May it please your lordship.
Ah,
Your lordship, I am challenging the rejection of the technical bid. This is to do with the reconstruction of the runway in the Dimapur Airport, my lordship, from chainage 50 to 350. My lord, here the subsequent development after filing this writ petition, your lordship, on paper we have been rejected on technical ground. A few days back, by checking the bid history, my client, the firm of the petitioner, has been able to find out that though the airport authority, they are claiming that our bid has been rejected on technical ground. By checking the bid history extracted from the portal, your lordship, it is found that our financial bid, the envelope 2, was also opened. And I have annexed that in the affidavit in reply, your lordship.
when have you done it?
Your lordship,
It has been given to whom? Who has got the contract?
your lordship, as of now, the work order has not been issued, but L1 is likely to get, your lordship, the respondent
Which
number 3.
L1?
Respondent number 3.
You?
Lordship, I'm appealing for respondent 1 and 2, Lordship. The
What is one
authority,
and two?
the Airport Authority of India.
Okay, you have filed your affidavit.
Yes, Your Lordship.
I have also filed my reply, your lordship.
And what is the present status? There's no stay.
There's no stay, Lordship.
No stay, your lordship.
L1 has been declared, the respondent 3 has been declared L1, Your Lordship.
You have filed, has the respondent number 3 filed the affidavit?
Yes.
Right. Okay, what is the ground for technical rejection? You are ready to do the matter?
Your lordship.
Are you ready to do the matter?
Yes, your lordship.
Yes, Your Lordship.
Your
Okay.
lordship.
What is the ground for technical rejection?
Your Lordship, if may I take you to our NIT
Clause 3, Your Lordship. Page 23.
Clause
Clause C.
3.
Yes, page 23, clause C. This is the qualifying requirements of contractors slash tenderers.
Clause 3 has been struck off.
3. Clause
2C.
2C, 2C, Your Lordship.
2C.
2C, there is no 2C.
Page 23 of the writ petition, Lordship.
2C, okay.
C, then Roman.
Qualifying requirement of contractors, tenderers containing
the
following.
following.
Yes.
Yes, Lordship.
What is the ground for rejection? Where is the technical minutes?
There is no separate technical minute on 12th, Your Lordship. It was published on the website.
Your Lordship, there are.
It is observed that your document submitted was not criteria regarding your experience criteria. You have not submitted undertaking for the parent company as a way it was not submitted to the impact submitted. So there are many reasons. Annexure 6, page 47.
Yes, Your Lordship.
First is that your experience certificate. Your document submitted was not as per ENIT criteria regarding your experience certificate. Where is the NIT?
NIT is at page
Your Lordship, it starts from page 16.
16.
Understood. Is it the entire one?
Except the annexures, Your Lordship, the appendix, Your Lordship. This is the entire document.
It can't be the entire document. Okay, let us see.
Your Lordship.
Yeah, qualifying criteria. Qualifying criteria is has successfully completed or substantially completed 3 works of rupees so and so, or 2 works of so and so, or 1 work of AI in a single contract of so and so, so and so, so and so. Why I say the entire thing is not there? It is to be in Form A.
Your Lordship. That I have annexed in the affidavit in reply, Your Lordship, because some pages where the alphabets were too small, the font, and that may require retyping, Your Lordship.
Where is the affidavit in reply?
Your Lordship.
It
was filed yesterday, my Lord.
Where? I don't have the affidavit in. Affidavit in reply. You have the contract document, the entire one.
Your Lordship, I may be allowed to call my engineer department. He has the file.
Please do. You have the entire contract document, tender document.
Your Lordship, the form is at page 30.
NIT. Full, complete. And full analysis. This is our analysis.
You give it to me. Let me try to find it out. It would take less time.
Give it like this one. These are the ones that
This is the petitioner's bid. Why do you say his integrity pact is incomplete?
Your Lordship, his integrity pact is incomplete because he has not signed in the integrity pact. And also he has not.
I have annexed in the affidavit in reply, Your Lordship. All pages are signed, my lord.
And your Lordship, PQ form also was not submitted at the time of submitting the tender.
No, Your Lordship, that's misleading. It's also in the tender document which I have annexed in the affidavit in reply, my lord. The only document which by an oversight which was not submitted is Appendix 8, Your Lordship.
Your
It
Lordship,
is a minor document, my lord.
Your Lordship, in our summary report, Your Lordship, in my counter affidavit.
Give it to Mr. Joshua Saki. Is this your integrity pact?
Yes, Your Lordship.
Okay. Oh, where is the date?
The date is not mentioned, Your Lordship, yes.
Then you see the next page. The next page, the last page of the integrity pact.
Your Lordship.
There's a column out there. Has anybody filled up?
Your Lordship.
That over?
No, Your Lordship,
No.
my lord will kindly appreciate the clause 7, my lord.
I'm not on that, Mr. Seki. Integrity pact has to be signed. That is a must in all government of India, government of Assam, government of Nagaland.
Your Lordship, in their rejoinder page number 39, they have signed it here subsequently, Your Lordship.
This is not that.
But initially it's not there, Your Lordship.
Your Lordship, we have signed at the bottom, Your Lordship.
How is it possible? Who has signed it?
Signed by the petitioner, Your Lordship.
Tell me from there, who has signed it? Where's the designation? Doesn't the form say that you have to put the designation who has to sign it?
Your Lordship.
Matter over. Sure.
Your Lordship,
Your Lordship, in the first
One thing
integrity, Your Lordship,
why other things we don't require?
name has already been entered, Your Lordship, as represented by Mr. Tovi Jakalu.
Where is it signed?
Your Lordship.
Where is it signed next to it? You have to sign it there, not down below. This is not a signature. Integrity pact is what? Look here, I am saying that I don't come within these parameters. I have not violated. I would not violate. I would not force the Airport Authority of India to give me this particular contract. I would not come or try to bribe anybody. These are all contracts. These are undertakings. You don't give undertakings like putting a signature down below.
Can my lord consider the second aspect?
No, one aspect is enough.
To Your Lordship, the envelope 2, the financial bid was opened, Your Lordship. If it was rejected at technical bid stage, then what was the necessity to open the envelope 2, that is the financial bid, Your Lordship?
How does it matter? I would have understood that you were held to be technically incompetent. And thereupon, if a financial bid is opened or in the case that you are going to have any effect or it would impact upon you in that particular contract, you have given a financial bid that this I am going to do it at this amount. Isn't it? Now, as of now, whoever being given, let us assume that your financial bid has not been opened. The financial bid of Madam Jimomi's thing has been opened. Now, as of now, you know it.
Your Lordship.
You know what is her bid.
Minus 15%, and we have quoted minus 25%, Your Lordship.
Therefore, you have come.
No,
Otherwise,
no.
would you have come?
No, Your Lordship, not on that ground, my lord. My lord will kindly appreciate this.
Mr. Seki,
Your Lordship.
Mr. Seki, if you were minus 7%, is it?
Lordship.
And theirs is minus 15%, would you have come? No. Because trying your luck out here
No, Your Lordship,
not be successful out there.
my lord may kindly appreciate this aspect. There is a clause within the NIT itself, clause 7, which clearly says that there is a window period to be open for clarification, Your Lordship. Now,
clarification is always prior to that.
No, Your Lordship.
You see, I tell you how the contract works. First, the NIT. date on which the NIT is issued. Second is the period of clarification. Third is the period of bid submission. Then, in the case of prior to that, there will be a case of pre-bid meeting. Then bid submission. Bid submission, then last date of bid submission. Then open, everybody then finds that the results.
No, my lord will, surely my lord is well,
I am not well, but this is how it is done. Here, kindly see. In the notice inviting tender only, they will give the details.
no, that part is understood,
Page
my lord.
21, Lordship.
That part is understood, my lord. My lord, may kindly allow me to take the lordship to
See,
clause 7.
bid document sale date, clarification end, then bid submission date, bid submission end date, last date for submission of the BD so and so, bid opening date, bid opening date.
May I take your lordship to clause 7? If my lord may kindly appreciate clause 7.
The
If it-
bidder is submitting a tender to the authority for what?
Your lordship,
Blank. See the integrity pack, it is blank. So it's an incomplete integrity pack. Now, without an integrity pack, you cannot be considered. There is no quarrel with that. And I think it is a term of the tender condition itself, I suppose, somewhere. Which clause? Integrity pact is a must.
your lordship, I also read somewhere. I'm trying to find out your lordship.
Your Lordship, in page number 21, bottom below, page 21, bottom below, technical bit containing the following. These are the enclosures mentioned, Your Lordship.
Scan copy, tender documents, scan copy, so and so, scan.
It will be in Roman 8, Your Lordship.
Huh?
Roman 8.
Scan copy of the
Sign
sign integrity as per
Right.
appendix
So-
3.
so- Yes, Your Lordship.
Then there will be another clause. If you don't give any of the documents, it will be rejected. Where is that? EMD envelope 1. If not paid, remand technical bid and so a bid containing following. Scan copy of the security bond, so and so, so and so, so and so. There will be a mention. The scan copy of all documents in the mention shall be submitted. It not be in the line so and so.
Your Lordship, it will be page 24, bottom below.
Where?
Page 24, bottom below, scan copy of document in that.
Shall be submitted on the
yes,
CPP portal.
portal. The last 3 lines, the tender whose insures so and so are not received by date and critical date, tenders will be liable to be rejected.
It's a
Your Lordship, page 37 also.
Yes.
Page
28, Your Lordship.
37.
Page 37.
Page 37, Lordship. The heading is rejection of tender. C.
E, 25E. H. Chalo. So integrity pact is not there. Then
Your Lordship, it may not have been signed in the box itself, but there is a seal and signature of the proprietor, my
how
lord.
does it have any relevance like this?
Your Lordship, if I may take
He
your
has not filled up anything. The date is not there. What is the value of an integrity pact which doesn't have a date? Tell me. Give me a good reason why. There's not a single date. You may tomorrow say, yes, I signed these things somewhere else, not here. Where's the date? There's not even a single date also.
Perhaps the same could have been clarified under clause 7, my lord.
And Mr. Counsel, you see,
My lord.
kindly see who has signed it. Signature of the bidder. These are all empty. See? That is why I am showing. This is empty. In the box also, the name is not given.
My lord, I have already seen.
No, you just said the name is given. There's no name given there also.
Name is in the first page, your lordship, at appendix 3. And in the second paragraph, MS No Hassle Deal represented by Mr. Tovi Jakhalu.
But that has no relevance. No, who has signed it? There's no signature out there that this is his signature. How will they know? Unless they have been very close to you.
Your lordship.
I would have understood it. Madam, next time onwards, when this Hassel and No company applies, put Mr. J. Sekia in the board. Then he may know his signature. I have not been able to know his signature.
Your Lordship, if I may take it just to 2 pages.
Yes.
Page 26 of my counter affidavit, Lordship. Page 26, annexure 4.
This is the
This is the scrutiny sheet, Your Lordship.
Yes.
This is the scrutiny sheet of all the 4 bidders. The second is no hassles. Your Lordship, if you come to serial number 12, it's written undertaking from parents company as per appendix 8. If you, Lordship, if you come this side, Your Lordship, it's written not submitted.
Where?
Page 26, serial number 12, undertaking from parents company as per appendix 8. My lords have it. If you look at no hassles column, it is written not submitted. And also the next page, Lordship, page. The next page, page 27, serial number 22, Lordship, PQ performer duly filled. Your Lordship, if Lordship will look at Messrs. No Hassle deal, it's written not submitted, Lordship. And this is CPP portal generated, Lordship. It is not through my own officers or from our website. It is through portal, Lordship.
Your Lordship, they feed the information on the portal, Your Lordship. The only automatically generated system, Your Lordship, when it will be triggered is when the file is opened, Your Lordship. When the envelope is opened, there's an automatic trigger. So, my lord, in this case, my lord, as far as the automatically triggered system is concerned, they claim that it was opened and forked, the technical bit. It was never opened and forked, Your Lordship, because no SMS came, no email came. Now, this is There's no possibility for manipulation by any party, Your Lordship.
Madam, why you are going into unnecessary things? One infraction is enough.
Your Lordship, that's what we have rejected him because he did not met with the eligibility criteria, Lordship. Its main contention in the writ petition, Lordship, is that clause 7 provides we could have called for shortfall. Lordship, the shortfall when we could have called if he would have met with the eligibility criteria, he did not met, Lordship, and it is not a case that we have done arbitrary. There were 4 bidders, Lordship. 2 were rejected, 2 were accepted. We have not called shortfall from any. Even the other rejected Mrs. Trident, his nature of work was as per our NIT, but Your Lordship, his value was less.
Miss Trident also has a problem.
No, Your Lordship, they have not filed the case.
Understood. They have understood. Their integrity pact is similar.
Lordship, and also their
Same integrity.
and they have also not met with our eligibility criteria. We have rejected them also, Lordship.
See, how these integrity pacts should have been done is this. You see, Trident also did the same.
Yes, Your Lordship.
Integrity pact should be like this.
Your Lordship.
Next time, advise your client.
Well, as far as the eligibility criteria about the semblance of the work is concerned, Your Lordship, my
See,
client,
No, why should I
Yes, Your
look to
Lordship.
other thing? See, integrity pact, how it is
Hello.
done. Not that like Trident also didn't give. That is why while I was looking into this, I was also seeing as to whether Trident have they been given, because they also did not submit. See, earlier bunch, you will find Trident, same like you. Trident must be nearby your place. Both of you have joined together.
Your Lordship.
Okay, let us dismiss your petition then. Heard Mr. J. Sekidal and counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers
1 and 2, Lordship. Priyana Chetri.
2, and Ms. J. Z. Zimomi appears for the respondent number 3.
If my Lord heard me, I would also have many authorities, but on this point, Your Lordship,
The petitioner herein has approached this court challenging the tender summary report dated 12/2/2026, whereby the petitioner's technical bid was rejected, and thereby declaring the firm of the private respondent number 3 as L1 and the firm of the private respondent number 4 as L2. Next. The brief facts of the instant case are that the Airport Authority of India, that is the respondent number 1, had issued a notice inviting tender, e-tender, thereby inviting eligible contractors to participate through e-portal for reconstruction of the runway from Cheney's 50-meter M to 350 M with rigid pavement and associated works at Dimapur Airport, -SH, all caps SH, then :I, strengthening of affected area of runway 30/12 and allied works. Why don't you just check it out? Annexure 1, page 16, how it is given. In terms with the said notice inviting tender, for short, the NIT, in the said notice inviting tender, for short, the NIT, a critical date sheet have been incorporated. In terms with the critical date sheet, the bid document say download/sale start date was on 9/1/2026 from 9 9:30, 0930 hours. Clarifications. Start date was 9/1/2026 from 0930 hours. And the clarification end date was 16/1/2026 up to 1800 hours. The bid submission date was on 9/1/2026 from 0930 hours, and the bid submission end date was 30/1/2026 up to 1800 hours. The last date for submission of the original insurance surety bond /BG against EMD, if not paid online on CPP portal, was on 3/2/2026 up to 1800 hours. It is also seen from a perusal of the notice inviting tender from the NIT that the bid were required to be submitted in two envelopes. Envelope number 1 was in relation to technical bid and pre-qualification documents. Envelope number 2 is the financial bid. Clause 2, capital B of the NIT stipulated the documents which would form a part of the technical bid. Subclause Roman 8 is the scanned copy of the signed integrity pact as per Appendix Roman 3. Subclause Roman 10 is the scanned copy of Form A. That's details of similar works completed during the last 7 years with completion certificate issued by the client. Clause Roman 16 is the scanned copy of digitally signed undertaking from the parent company as per Appendix Roman 8. What is this PQ business, madam? What is PQ?
Pre-qualification.
Which is there? The requirement to Clause Roman 24, subclause Roman 24 relates to the PQ performer duly filled. Clause 2, capital Roman 6 C, stipulated the qualifying requirements of contractors / tenderers containing the details as regards completion of works These details are to be provided in the given form capital A with supporting documents issued by the client. The notice inviting tender also included the general instructions for online bid submission in Appendix A. There is also another document enclosed to the said notice inviting tender, that is the general guidelines for the bidders. Clause 25 of the general guidelines to the bidders stipulates when the Airport Authority of India can reject a tender. Subclause E, F, G, H being of clause 25 being relevant are reproduced herein under page 37. Clause 28 stipulates the implementation of the Integrity Pact. In terms with clause A of subclause A of clause 28 of the general guidelines for bidders, signing of the Integrity Pact as per Appendix Roman 3 is mandatory for each bidder oblique contractor in the procurement oblique bid process. The Integrity Pact is required to be signed on each page by the person authorized by the bidder to sign the bid for submission or the person authorized to sign the contract on behalf of the successful bidder. The scanned copy of the same has to be uploaded by the bidder, bracket open, along with an unconditional acceptance of AI's tender conditions, bracket close, in the envelope 1. In the backdrop of the above, this court finds it pertinent to take note of that the petitioner, along with 3 other bidders, participated in the said tender process, which included the respondent number 3 and respondent number 4. The petitioner's bid was rejected on 11/2/2026. On the ground of not meeting NIT criteria. Thereupon, on the same date, the financial bid was opened of the respondent numbers 3 and 4. And the respondent number 3 was found to be the L1. The records reveal that on 14/2/2026, the petitioner, on coming to learn about the opening of the financial bid, about the rejection of the petitioner's technical bid and the opening of the financial bid, submitted a representation questioning the decision to reject the petitioner's bid, technical bid, alleging that it is a case of foul play in order to choose the blue-eyed person of the authority. To the said communication issued by the petitioner on 14/2/2026, the respondent number 2 issued a communication on 17/2/2026 informing the petitioner that the petitioner's bid were rejected on 4 grounds. The petitioner's technical bid was rejected on 4 grounds. They were, number 1, the petitioner had not submitted the experience certificate as per the ENIT criteria, that is in Form A. Number 2, the petitioner had not submitted the undertaking from the parent company as is required in Appendix Roman 8. As per Appendix Roman 8. Number 3, the PQ performer, which was required to be filled, was not submitted. And number 4, integrity pack submitted by the petitioner was incomplete. The petitioner thereupon submitted another representation wherein on 18/2/2026, wherein it was mentioned that the PQ performer was duly filled as per the NIT, and the petitioner had submitted the Form 8 separately enclosed as Annexure 1 for the ready reference. It was also mentioned that the PQ, there was not sufficient space provided for writing. It was also mentioned that the experience certificate as per the ENIT criteria of similar work pertaining to NH road no clarification was sought from the petitioner for that work. Be that as it may, from the very representation, it is apparent that the petitioner duly admitted that the Integrity Pact, though submitted as per annexure, those submitted, but the missing those submitted, but there was no signature of the witnesses, which could have been resolved by seeking resolved through shortfall documents. It was also mentioned that insofar as non-submission of Appendix Roman 8, the petitioner missed out as the same was submitted, as the bid was submitted at the last hour. The petitioner thereupon, being aggrieved, had approached this court by filing the present petition. The record reveals that this court, by an order dated 22/2026, issued notice. However, no interim order was granted. This court finds it very pertinent to take note of that in the meantime, the respondent number 2, respondent number 3, who has filed the affidavit? You have filed.
Your Lordship, we filed on 12th.
Where is your affidavit?
My affidavit, Lordship, is there. 12th.
I read somebody else. Oh, yeah.
My affidavit just now, Your Lordship.
It is seen from the records that respondent number 2, 1 and 2 have jointly filed an affidavit. Raising various preliminary objections to the maintainability of the writ petition. While denying to the various allegations made in the writ petition, it was the decision of the respondent authorities to reject the petitioner's technical bid was was elaborated by by giving reasons. This court finds it very pertinent to take note of Annexure 4 to the said affidavit in opposition, which is the scrutiny sheet of the four bidders. Insofar as the petitioner is concerned, the petitioner had not submitted the undertaking from the parent's company as per Appendix Roman 8. This aspect, the petitioner also duly admits in the representation dated 18/2/2026. Insofar as the PQ performer, it is mentioned that the petitioner have not submitted. Where is the affidavit in reply?
Your Lordship.
The affidavit in reply. You have a copy? Anybody has a copy?
Rejoinder account, Your Lordship.
Their affidavit
Oh,
in reply. This court has duly perused the bid submission confirmation. A perusal of the said bid submission confirmation shows the various bid documents which the petitioner had duly submitted. The said documents containing the various file names and its description do not show that the petitioner had submitted the PQ. Yes. No, yes, yes. Madam, if you see his document, bid submission document, there's a PQ field. That what do you say that?
Pre-qualification.
Huh?
Pre-qualification, PQ, Your Lordship.
PQ duly filled.
Duly filled, Your Lordship.
Kindly see this document. This is his bid submission, na? Need a circle. Yes, show me this.
My lord, these are mentioning on the portal. These documents are mentioning on the portal.
He has only mentioned in the portal,
Ah,
but inside it was not there.
yes.
Madam, what did I say? No, show that a file bearing number being filed, a file name being PWD underscore registration dot PDF mentions pertaining is being described as PQ performer duly filled. This court inquired with the learned counsel appearing on behalf of the respondents that from a perusal of the bid submission, so confirmation, it appears that there is a PQ performer duly filled. In that regard, it was mentioned that though in the bid submission document, it is mentioned that the PQ performer duly filled, though in the bid submission confirmation, there is a mention that there is a description that the bid PQ performer duly filled, but the documents which were submitted was not in relation to the performer PQ which was required to be filled. In fact, there was no such performer which was filled. Be that as it may, a perusal of Annexure 12 of the affidavit in reply, so submitted by the petitioner, reveals that this PQ pro forma was uploaded. And reveals. Post. This court further finds it pertinent to take note of that in the scrutiny sheet, it is also mentioned that the experience certificate submitted by the petitioner is not meeting NIT criteria. In as much as the work in question, in as much as the work referred therein was not immediate. In addition to that, the respondents have also enclosed the various other documents which have been filled. Which was submitted by the petitioner. A pre-qualification pro forma in respect to another bidder, namely MS Trident Enterprise, was also enclosed to the said affidavit in opposition. Giving details as to how the pre-qualification pro forma is required to be filled up. The respondent number 3 has also filed an affidavit in opposition. However, taking into consideration that the contents of the said affidavit in opposition of the respondent number 3 is almost similar to that of the respondent numbers 1 and 2, this court, for the sake of brevity, is not repeating the same. Is not detailing out its contents. The record reveals that an affidavit in reply has been filed by the petitioner, wherein various documents have been enclosed, which the petitioner claimed to have submitted. I think I see the imposed cost.
But Lordship, as far as
This document is not what it is there, because if the
Lordship.
no, Mr. Counsel,
Lordship.
if the integrity pact, what you are placing before the court is different from what is there on record.
Lordship.
Yes, your integrity pact is different. See, you have enclosed it.
So what I have seen from the Your Lordship's document and what I have is the same, Your Lordship.
Where is your integrity pact?
Your Lordship, in my affidavit in reply.
Yes, integrity pact. Kindly see. This signature is there. Signature of the bidder you have put at page 39. Now, if that is so, you are placing before this court some document which is not there, which you have not filed, means it is amounts to misleading or suppression. So we impose cost.
Your Lordship, in this aspect,
Yes, serious, very serious, very serious. Anyways, filed containing various documents, including the PQ, which PQ performer, which the petitioner claims to have submitted have uploaded along with the bid.
no, my lord, on this
As well
point, I
as
will kindly
the
be allowed to beg your
integrity
Lordship. My lord,
as well as the integrity pact which the petitioner had submitted. While uploading the bid.
this I may be allowed to clarify, my lord, from my client. Because if cost is imposed, losing the case is another aspect. But again, my lord,
Not you, not
without
upon,
clarification, my
upon your
lord, if
client,
cost is imposed.
upon your client, not to come before this court so lightly. This court have heard the learned counsels appearing on behalf of the parties in the backdrop of the pleadings. In the backdrop of the pleadings, this court have heard the learned counsels appearing on behalf of the parties. First, the submissions made by the learned counsels appearing on behalf of the parties being in line with their pleadings, this court, for the sake of brevity, is not repeating the same. Next. In the foregoing paragraphs of the instant judgment, this court have duly taken note of various provisions, various clauses of the NIT. First, this court also, during the course of the hearing, during the course of the hearing, the learned counsel appearing on behalf of the respondent number 1 and 2 have also placed before this court the bids, all the bids which were submitted by the 4 bidders, including the bid submitted by the petitioner. In the foregoing paragraphs of the instant judgment, this court have duly taken note of clause 28 of the general information to the bidders, general guidelines to the bidders, which stipulated as to how the integrity pact is required to be filed. It's required to be submitted. The records which have been produced before this court reveal that the integrity pact which was submitted by the bidder, by the petitioner, was an incomplete document taking into account that nothing has been filled up as to the date on which the integrity pact was signed, in respect to what tender, in respect to as to who is the signatory on behalf of the petitioner. There is no mention also. There's also no signatures of the witnesses. Rather, from the said integrity pact which have been uploaded by the petitioner reveals that the petitioner, that some person, the proprietor of the petitioner, have just signed, put its signature down below. Perusal of the said integrity pact so produced before this court in the form of the therefore is an incomplete document and without the signatures as is required, the same cannot be acted upon. In other words, the integrity pact, the documents which have been uploaded by the petitioner as an integrity pact is not an integrity pact, is not a submission of the integrity pact. And as such, the same, and as such, this court have also perused the records of the bids which has been submitted by the petitioner. And there is nothing that though in the bid confirmation document, bid submission confirmation document, there is a reference to the PQ performer duly filled. But there is no records of the same. But the said PQ performer is not found in the records of the bids so submitted by the petitioner. This court now takes note of the affidavit in reply so filed by the petitioner, and more particularly Annexure 12. The same document a perusal of the said document shows that the columns that only in respect to columns at serial number 3, 4, 5, 6, 7, 8, 9, 10, in columns from 3 to 27, except column number 10, 11. Have been filled up by putting a tick mark without, however, providing the details of submission. Insofar as clauses 27.1, 27.1.1, 27.1.2, 27.1.3, (28), 28.1, 29, the same have not been filled up. Further to that, the performer, the PQ performer, there is no date mentioned. At this stage, this court finds it pertinent to take note of the affidavit take note of. A PQ performer filed by MS Trident Enterprise wherein proper details have been given. Therefore, even assuming that the petitioner had submitted the PQ performer, the same was also an incomplete document. Insofar as submission of the parent company's undertaking in Appendix Roman 8, the petitioner in its representation dated 18/2/2026 have duly admitted the same documents have not been submitted. Next. This court now finds it very pertinent to take note of the settled position of law as has been held by the Supreme Court in the case of Jagdish Mandal. What is that? Jagdish Mandal? Which judgment you are bringing?
This is 2016.
15 SCC.
622.
What is that? Of course.
Lordship, Jagdish Mandal is 2007 14 SCC.
Versus Jagdish Mandal versus
State of Orissa.
State of Orissa. Reported in, give it to me.
2007 14 SCC, page 517, Manoj.
Wherein the Supreme Court categorically observed the scope of judicial review in matters pertaining to contractual, in matters pertaining to the decision of the tendering authority to accept or reject a bid. In the opinion, taking into account the said proposition of law which is well settled, and the fact that the petitioner herein have not submitted those documents, as have been observed, the various documents as have been observed herein above, the respondent authorities were within their rights to reject the petitioner's bid in terms with technical bid, in terms with clause 25 of the general guidelines of the bidders. Accordingly, this court does not find any ground to interfere with the impugned decision of the respondent authorities in rejecting the bid of the petitioner, for which the writ petition stands dismissed. Next time, no, you ask your client to be careful.
Lordship.
The records which were produced is being returned to Madam Swett.
My lords, may I mention item 23 and 24, if I may?
Why?
My lords, there's an interim stay in the order in the particular matter.
Sir, I am still in the midst of hearing matters are going on. Are you in the
Apologies, my lords.
thought that this court is writing?
My lords, I saw the court person coming from the behind. My apologies, my lords.
Practice where?
I jumped. Before the Delhi, my lords.
Delhi. So look into the court and then come. I don't rise so early.
Apologies, my lords.
Take your matter at
Sincere
5.
apologies.
Lordship,
For hearing item number 18.
My lord,
Yes.
the person is
Yesterday, I had fixed some matters to be taken up today. This is pertaining to what? Recovery
recovering, my lord.
after you have retired.
My lord, actually, what happened is this. You was illegally discharged. So the petitioner approached this honorable court by filing a writ petition. In the meantime, what happened is that they have deducted the GPF account in the live encashment. And there's demanding that the petitioner should deposit more 5,22,201.
What is the petitioner working as?
It is a supply.
Huh?
Supply in the Assam Rifles. So that the illegal discharge has been set aside by this honorable court.
No, you are asking for pensionary amount? What?
No. What I'm asking is this.
You just your prayer out there on the
The
petition.
petitioner was illegally discharged. So the petitioner approached this court. And that aspect of the matter has been settled by the single bench of this court.
So directing him to be reinstated.
No. Yes, earlier petition, that one is to reinstate. But the question before this honorable court is, they made illegal deduction and at the same time they are asking for deposit. Total amount comes to 12 lakhs something. So what before in this petition, the petitioner is saying that no, this is illegal.
Why such a huge amount?
My lord, what happened is this. The petitioner was earlier illegally discharged. This honorable court set aside that order. Then he was reinstated.
Then
that period of discharge was taken as a diasnat. Then the petitioner approached this court that he is entitled for it. This honorable court gave that it should be paid. Then what happened is this. The unit have taken it to the appeal. In this appellate court says that yes, he is entitled. Only the privilege is given to the respondent that whether he was gainfully employed somewhere or not. That aspect of the matter, they verified from the deputy commissioner in the SP of the concerned district. They found that he was not employed. Then, instead of going by this honorable court judgment order, my lord, I may be allowed to take your lordship to page 32. What happened after the proceeding before this honorable court as well as before the division bench?
So the division bench
Mother,
at page 30 and 31 held that the learned single judge did not look into the question of back wages
my lord,
in the perspective of whether
He was gained
The-
yes.
Whether subject is subject to the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee, the nature of misconduct, if any, proved against the employee, the financial condition of the employer, and other factors. On going through the impugned judgment and order passed by the learned single judge, we find that the learned single judge had not made any finding with regard to the propositions called out by the apex court. Thus, we are of the view that the issue of payment of back wages would have to be considered. However, as to the decision to be made would relate to the facts, we have the view that we are not in a good circumstance to question of back wages, if any, would be best considered by the appellants. Accordingly, the appellant is number 2 is directed to consider the back wages of the respondent, if any, for the period from so and so by keeping in view the propositions which have been reproduced in the foregoing paragraph. Then an order was passed on 13th of December 2019.
Exactly, my lord.
Wherein it was held that in view of that it is decided that the respondent to treat the said intervening period from so and so as his pensionable service. The notional pay benefits would be extended to so and so for the intervening period. However, his pay after reinstatement into service with effect from so and so be refixed notionally, and areas, if any, be processed for making payment to him. Process for revised pay fixation in terms of so and so. He also extended an areas of so and so be paid. In pursuance thereto, an order was passed. Impact so and so, so and so, so and so. Hereby discharges the said area from service, being incorrigible offender with effect from so and so, is entitled to get pension and service gratuity benefits as admissible under the existing rules. Then,
My lord, I may be allowed to impress
then
upon
not
your
only
lordship.
that, what they did, after that, after 1 year, then was any amount paid to you?
My lord,
Wait,
your lordship may kindly turn to page 35.
That is what I am reading it.
Yes. Para 7. A. Last one. Revised pay fixation in terms of 7 CPC with effect from 1/1/2006. He also extended in register of be paid to him. That is that amount. That is the whole amount. Not the back wages. So it is from 1/1/2006 up to date is the calculation sheet is given it page 21 of the affidavit in opposition, my lord. 21. The specific period.
No, wait. After this, what did they do?
My lord, after this, they fixed the error pay, revised pay fixation in terms of 7 CPC with effect from 1/1/2006.
No, no, my question is, after page 36, what did they do? If I am not wrong, Mr. Imti Longchol, let me see, as I could understand from the facts, just from a glimpse of it. You were terminated.
Yes.
Termination was held to be bad.
My lord.
In 2015. Okay?
My lord.
Then, for that period, they were not paying any amount, for which you filed another writ petition.
My lord.
The Single judge held that you are entitled to full back wages.
my lord.
Matter came up before the division bench. Division bench held that in view of the proposition of law, it is for them to adjudicate as to how the amount a person is entitled to. Isn't it? Now, pursuant thereto, we find this order being passed on 13th of December 2019. Okay. Now, 13th of December 2019, after this order, what amount did you get?
12 lakhs. $23,644.
They paid you.
My lord.
They paid you.
Yes.
Okay.
What is that amount, my lord?
No, wait. So they paid you 12 lakhs 23,660. Okay.
My lord.
Now, after that, when was this amount paid?
My lord, must be right after the reinstatement because the calculation said it is 28th October 2021.
28th of
Their
October.
calculation is by them.
So they paid in the month of 28th of October 2021, they paid
My
that
lord,
amount.
see, take it.
No,
This
understood.
amount I've received, that is what I'm saying.
Understood.
I may not be able to give the exact amount.
28th of August 2021, they received this 12 lakhs 23,660. Okay. Now, prior to that, you were discharged
My lord,
in the year 2021.
after getting this amount, again he was discharged.
No, because you were discharged on 22nd of March 2021.
My lord,
When did you get this 12 lakh?
before discharge.
Where is it your statement made?
My lord, I've not stated about
Then
that.
this is isn't it the most fundamental aspect? So your case, therefore, is now you have discharged me. In pursuance to an order passed by this court, this amount was fixed by an order passed by the Director General. A speaking order was passed by the Brigadier with the approval of the Director General Assam Rifles in 2019. You got that amount.
My lord,
Now, how can they make a recovery? Isn't it your case?
yes, they cannot. That is my whole case.
I understand that.
Yes.
This is your case. So therefore, my question is, when did you get that amount?
My lord,
That is the most pertinent aspect because on 13th of December 2019, they say that you are entitled to.
what I've stated is in page 5 of my petition.
No, Mr. Longsor,
Yes.
isn't it
Where?
your case, without going into this, what you have raised?
Wait.
My question is, Mr. Longsor, is this.
Yes, my lord, it was
no.
transferred in his bank account. It is
When?
here.
When?
Decade.
No, so your case would be, you have to, it appears to be like this. You were dismissed, terminated, you challenge it. Termination was held to be bad, you were directed to be reinstated. The period thereunder, you said that as the termination was bad, you are entitled to the full back wages.
Well,
Single judge passes the full back wages. After the single judge passes the full wages, they file an appeal. When they file an appeal, the court comes up and says that you need to adjudicate how much you are entitled to.
no,
Yes.
no.
Yes.
About
No.
the back wages.
No, Mr. Longsir, this is the direction passed by the division bench, page 30 and 31.
What I'm stating is that.
No, Mr.
Yes.
Longsir, kindly listen. Page 30 and 31 says that let the adjudicating authority look into it as to how much you are entitled to as the back wages, taking into these propositions. In pursuance to that, an order is being passed on 13/12/2019, saying that you are entitled to certain amounts. In pursuance to that, an amount of rupees 12,23,660 has been paid to you. Now the question is, how can you now recover that amount? That is the case, Mr. Yangavati. How are you not now trying to override the speaking order dated 13/12/2019?
There's judgment order passed by the division bench.
Division bench, what does it say? Kindly see page 30 and 31.
Yes.
Says, and more particularly come back to page 31. Thus, we are of the view.
The appellant number 3 shall take decision.
The appellant number 3, appellant number 2 shall take a decision on the question of back wages within a period of 3 months from the date of receipt. Now, appellant number 2 takes a decision on 13/12/2019 that he is entitled to this amount. In pursuance to that, an amount has been paid to him. If the amount is being paid in pursuance to the decision of the appellant number 2, without overturning the decision of the appellant number 2, how can you claim that amount from him? My question is that.
My lordship, can you come to my affidavit?
Yes.
At page number para 5, relevant is page number 9. Let me just read from the top, from the bottom, lordship. 1, 2, 3, 4. In compliance with my lordship. My lordship, correct. In compliance with the judgment of the petitioner, case was considered again by the competent authority, and he was granted notional pay fixation, lordship. Notional pay, not regular pay. Notional pay only from 15 to 2019, right? Maybe so and so. And no back wages were granted to him. The period was inadvertently paid, as the petitioner was inadvertently paid the back wages for the period, for the said period, as on oversight, due to oversight.
No back wages was granted to him. How is it possible?
No, that is revised as per 7 CPC only. Only the revision part, not the back wages.
And therefore, it is decided by the respondent authority to treat the said intervening period from so-and-so to so-and-so as his pensionable service. The notional pay fixation would be extended to so-and-so for the intervening period. Hence, his pay after reinstatement with effect from so-and-so be refixed notionally and areas be processed for making payment to him. So it is very clear that you are giving him the back wages.
Yes, it was fixed as notionally, but inadvertently due to inadvertent, he was being given the back wages. That is why for recall.
No, Mr. Yangavati, when the word used out here is, hence his pay after reinstatement into the service with effect here be refixed notionally, and areas, if any, be processed from the for making payment to him. So therefore, you are to pay from 2020, 2010, 15/5/2010 to so-and-so is a pensionable service. You have considered it to be his pensionable service. The notional pay fixation would be extended to so-and-so Molang for the intervening period.
Yes, notionally.
So notional pay fixation will be there. So as per the areas of the 7 CPC, you are going to give him the benefit of that by fixing it. Hence, his pay after reinstatement into service with effect from so-and-so be refixed notionally.
Yes.
Means you fix notionally.
Yes.
And areas, if any, be processed and for making payment. This word and areas if any, be processed for making payment to him. Now you have not made any payment to him at that point of time. So areas which were there has to be back wages because process for revised pay fixation in terms of so and so be also extended in areas if any thereof be paid. The speaking order is so and so. Now does this speaking order not say that you are entitled to, does it say that no, I'm not going to pay the back wages because there was a direction specifically. Whereas the decision, let us see how does it go.
My lord, what my learned friend is submitting is the factual position.
Whereby intervening period with effect from so and so was treated as dice note and pay and allowance for the said period was not extended to in principle of both work. The fact whether the so and so was employed during the period he remains charged with effect from so and so has been inquired by the department and so that they verified that the prisoner was not employed anywhere. He himself was submitted for the state. The point of concern for a young man like person work or employment for 5 years of the period has not been our teachers were being of incorrigible offenders, however he not been informed of the child has been performed in unfair and he cannot be granted pay just for the remaining charge for the period and has to be that's just what that period has. The teaching goes to carry the period. No, Mr. Longshore, are you not challenging this order then? Are you not challenging this order?
My lord, this speaking order,
Have you challenged or not?
my lord, we file a contempt for non-compliance with the division bench order,
Then,
which is pending before this court.
okay, then we have it with because it is before the division bench. Because you see what the court say,
Yes, inquire.
you are to look into how much, what back wages should be given, taking into account these aspects.
My lord,
But you have not done so. But
No.
don't you think that you need to file that challenge that speaking order?
my lord, what?
You see, the contempt may do what? That you are wrong, comply. But this is an order which has been passed wrongly. You see, the division bench
Yes,
order.
I understood your lordship. Yes,
So you do one thing.
my lord,
You amend the instant writ petition
my lord.
and challenge that order.
Or by filing to be club up with this honorable.
Okay, you file
Yes.
another one then.
Yes,
Because without a challenge
my
to
lord.
that order,
Yes,
you will have difficulties.
Yes. I have understood.
You challenge that order.
This sort of hearing, this is in the hearing stage. Now, whether you can amend that after the hearing of the petition. If it's in the admission stage, you could have made amendment, but in the ultimately after knowing the opinion of the court.
Mr. Longsha, what do you want to do?
But I may be given some time.
You file another writ petition.
Mother,
File a writ petition, then
it will
take
not
this.
affect me, but it will affect the petitioner. Take it that it was my wrong approach, even taking the worst view of the matter, because contempt has been filed.
Contempt would not help you.
My lord, I understood that. Yes, it cannot be quashed.
Let me formulate that point and you file a writ petition.
My lord,
Heard Mr. M.T. Longshore, the learned counsel appearing on behalf of the petitioner. Mr. The petitioner herein has approached this court challenging the communication dated 13/5/2022, whereby the respondent authorities recovered an amount of rupees 7,01,459 from the pensionary benefits of the petitioner, and further demanded an amount of rupees 522,201. It is very pertinent to take note of.
Your lordship reference is 4th June 2022. The second part.
Which one?
4th June, that is page 39.
Now, 39 is subsequent. But
Yes.
This is 13th of May 2022. Page 38A or 38.
38 in 38A. In 39 also.
In addition to that,
yes,
the petitioner have also assailed the communication dated 4/6/2022, whereby the petitioner was directed to deposit the said amount. The case of the petitioner herein, as it appears from the materials on record, is that by an order dated 15/5/2010, the petitioner was discharged from the Assam Rifles. A challenge to the said discharge order was put by the petitioner by filing a writ petition being WPC number 3K/2015. The learned coordinate bench of this court, by the judgment and order dated 29/7/2015, set aside the order of dismissal order of discharge dated 15/5/2010 and directed that the petitioner be reinstated to service within a period of 3 months from the date of receipt of the certified copy. Full stop. The petitioner, upon joining or upon being reinstated, claimed that the petitioner ought to have been entitled to the back wages on the ground that the petitioner's discharge order was held to be passed by an officer who was not the competent authority. The non-granting of the back wages led to the petitioner filing another writ petition before this court, which was registered and numbered as WPC number 17K/2017. The learned coordinate bench of this court, by the judgment and order dated 25/7/2017, directed the respondent authorities to pay the petitioner his pay and allowances for the period from 15/5/2010 to 19/9/2015. The respondent authorities herein, being aggrieved, preferred, and appeal being the writ appeal number 3K/2018. The learned division bench of this court, by an order dated 29/5/2019, though interfered with the judgment and order passed by the learned single judge by the learned coordinate bench dated 25/7/2017, passed in WPC number 17K/2017, but did not hold that the petitioner was not entitled to the back wages. The learned division bench, on the other hand, held that instead of the court deciding as to the quantum of the back wages for the period from 15/5/2010 to 19/9/2015, it should be best left to the respondent authorities to decide the entitlement of the petitioner's back wages, keeping in view the law laid down by the Supreme Court in the case of Dipali Gundu Swarsi versus Kranti Junior Adhyapak Mahavidyalaya, reported in 2013, 10 SCC 324. The appellant number 2 in the said writ appeal, who is the respondent number 2 in the present proceedings, was directed to take a decision on the question of back wages within a period of 3 months from the date of receipt of the certified copy. In pursuant thereto, on 13/12/2019, the respondent authorities, more particularly the respondent number 2, instead of deciding as to what should be the back wages paid to the petitioner, applying the law laid down by the Supreme Court in the case of Dipali Gundu Swarsi Supra, as well as the judgment passed by the learned division bench of this court dated 29/5/2019, held that the petitioner was not entitled to a single penny, and thereby treating the period when the petitioner was discharged from service from 15/5/2010 to 19/5/2015 as dies non for the purpose of pay and allowance, full stop. Be that as it may, comma, the respondent authorities paid an amount of rupees 12,23,660 to the petitioner. Full stop. It is very also pertinent to take note of that immediately upon the payment, comma, the petitioner was again discharged from service by the competent authority by an order dated 22/3/2021. On 13/5/2022, the respondent authorities, instead of computing the pension to which the petitioner was entitled to, have rather appropriated the pensionary benefits to which the petitioner was entitled to, have not only appropriated the pensionary benefits which the petitioner was entitled to, but also directed the petitioner to pay an additional amount of rupees 5,22,201. It is under such circumstances the present writ petition has been filed. This court, during the course of the hearing, inquired with Mr. I. Longcha, the learned counsel appearing on behalf of the petitioner, as to whether the order dated 13/9/2019 have been put to challenge. The learned counsel submitted that the petitioner had approached the division bench of this court.
Single bench.
Single bench.
Man.
Had filed a contempt application before this court, seeking non-compliance to the order passed by this court. Compliance to the order dated 29/5/2019. He, however, with all fairness, submitted that the order dated 13/12/2019 have not been put to challenge on an assumption that the petitioner herein can get the relief in the said contempt proceedings. It is the opinion of this court that in the contempt proceedings, the court can, at best, pass appropriate orders for if there is a willful and deliberate violation and punish the contemner. However, till the impugned order dated 13/12/2019 remains, the petitioner cannot get any benefit in the present proceedings. The learned counsel, therefore, for the petitioner, therefore, submitted that some time may be granted to the petitioner to assail the order dated 13/12/2019 and the instant writ petition be kept pending. List this matter when?
After 4 weeks.
List the matter after 4th of May? 4th of May. In the meantime, the petitioner would be at liberty to file a writ petition challenging the order dated 13/12/2019, if so advised. Yes. I gave you this liberty, so.
For hearing item number 32.
What is the matter about? Oh, this one. Land compensation.
So always observed yesterday, if I may given a direction to approach the court below.
Yours is the same one, na?
Yes, Your Honor.
This is a damage being caused to you
Yes, my lord.
on account of
The construction of two-lane road.
the two-lane road.
Yes, my lord.
And we waived the period for the purpose of limitation, huh?
Yes, my lord.
When did you file the writ petition?
2022.
Where is the date of filing?
15 December 2022.
2022.
22. Yes, my lord.
Okay. Dekho. Have you got any amount?
My lord, basically in the initial part,
Hmm.
I have received certain amount,
How much?
which is not disputed, somewhere around 1,57,280. That I'm not
1
disputing.
lakh?
1,57,380.
380. Abdul lakh, yeah, hope. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Who is appearing for whom? Mr. Muajam, you?
For 6, my lord. This one number 6.
State of Nagaland? Mr. E. Form appears on behalf of the state of Nagaland. Mr. Yangawati, for respond numbers 1, 3, 4, 5. You appear. Mr. Yangawati appears for respond number 2. Mr. So-and-so appears for respond number 6. And Mr. Muajami appears for respond number 7. The petitioner herein is agreed by the inadequacy of compensation paid to the petitioner on account of the damage caused to the petitioner's properties in view of the construction carried out construction of the two-lane carried out on Changtonga Longlang Road. Which one? In?
Mon Tamlo Merango.
Huh?
Mon Tamlo Merango.
In the Mom Tamlu Merango Road. The petitioner was merely paid an amount of rupees 1,57,380.72, whereas as per the petitioner, the compensation should not be less than rupees 62,35,190. It is the submission of the learned counsel for the petitioner that this amount which the petitioner claims is as per the report and estimates prepared by the WNW construction based on the existing Nagaland PWD schedule of rates of 2021. Full stop. It is the opinion of this court that as the petitioner herein, as to how much the petitioner, it is the opinion of this court that the grievance of the petitioner herein is as regards the inadequacy of the compensation provided to the petitioner for the damage caused to the properties of the petitioner on account of the construction of the road. First, this inadequacy of the compensation cannot be adjudicated by way of in the writ proceedings. Inasmuch as it would involve adjudication of the tendering of evidence and adjudication on various intrinsic and as well as adjudication, intrinsic adjudication on evidence of factual disputes. It is under such circumstances it is the opinion of this court that this court cannot entertain the instant writ petition. That this court would not be the proper court for adjudication of such disputes under Article 2 to 6 of the Constitution. Be it as it may, this court, however, observes that the petitioner have been diligently and bona fidely pursuing the present writ proceedings. Under an impression that this court would be in a position to adjudicate the present dispute, present lease. And as such, if this court is not entertaining, the period, it is the opinion of this court that the period from the date of filing of the present writ petition till date should be excluded while computing the period of limitations in filing a suit. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, this court, in view of the reasons stated above, is not inclined to entertain the instant writ petition as it involves pure questions of facts, pure factual adjudications. Number two, the petitioner is given the liberty to approach the competent civil court claiming damages for the loss felt by the petitioner on account of the damage to the properties of the petitioner due to the construction of the road in question. Number three, the period from date of filing
15/12/2022.
(15/12/2022) till date be excluded while computing the period of limitation.
For hearing, item number 33.
Yes, what is this? Hey, put that in the other file of Mr. Longshore. Yes.
In this matter, I'm challenging I'm questioning the eviction proceedings initiated by the state against the petitioner.
You are asking for what?
I'm questioning the eviction proceedings initiated by the state against the petitioner under the Nagaland Evictions of Persons in Unauthorized Occupations Act.
Proceedings. Was the impugned order insofar as respondent 9 is concerned holding the petitioner and to properly clear? Okay. Where is that order? 18/7? Where? Impugned order?
Yes, one is at page 23.
How many are there?
And the subsequent.
We are only concerned with one order.
Yes. Subsequently, the
23.
53.
No, this 18/7 is where? Where is the 18/7 order?
23.
Okay. Where is an appeal has been filed under 12 of so and so. Okay, then. Therefore, it is therefore ordered that the Deputy Commissioner is directed to initiate afresh necessary proceedings and take steps as per the provisions of the Eviction Act, giving due diligence in issuing necessary order notices in terms with the procedure as enshrined. However, for the sake of in my consider the plot of land in issue located in NST so and so occupied by the appellant is a public land, government acquired land, and as such initial transaction made within a private party without knowledge, concurrence of the government is illegal. The issue of whether the land in occupation of the real issuance upon the part of which claiming title has already been decided and disposed of. Now, what is this case?
Well, initially the petitioner, he purchased a plot of land from one person A. Now this person, thereafter, he files a suit against the state, claiming that the state was interfering with his possession. In that suit, a decree was passed ex parte because the state failed to appear, despite the summons being served. Ex parte decree was passed. But thereafter, a third party who was not involved in the initial suit, he filed an appeal. Now those proceedings were taken up, but ultimately was dismissed on the ground of being abated. Finally, the ex parte decree attained finality in 2014. Thereafter, the state.
Who got the ex parte decree?
My vendor.
Your vendor got
Yes.
it. Okay.
Now, thereafter, the state started issuing eviction notices under the Act. It happened that first notice was issued to one person. Now, this person took the matter to the High Court. The High Court said that despite the existence of the ex parte decree, in view of the course title in the decree, which says that Chief Judicial Magistrate, of course, in addition to other reasons, the court directed the petitioner to file a suit. Thereafter, the eviction notice was also issued against the petitioner. Now, the ground taken by the petitioner was that in view of the existence of the ex parte decree, the state could not have resorted to issuing eviction notice under the Act, but the state should have filed suit if at all they want to evict. Because
in other words, you say that when there is a bona fide dispute,
yes,
the question of the ex parte decree raises the bona fide dispute.
Yes.
And when there is a bona fide dispute in respect to the land, the question of exercising jurisdiction under Section 5,
of the Act
4
does
and
not
5
arise.
of the Nagaland Public Premises Act does
Yes.
not arise.
Yes.
That's your case.
Yes, and the land does not vest with the state. There's no positive.
Whether it is there or not, that's another thing.
Yes, that's another question. But basically,
But
that's the case.
taking into account that there is an ex parte decree, it is therefore a bona fide dispute.
Yes, and therefore, if all the state wants to evict the petitioner, then they can
have
file
to
the-
file a suit.
Yes,
Not by this summary.
not by the petitioner, and
Summary.
not through the summary proceedings under the Act. And the state also in the affidavit has admitted to the fact that yes, this dispute involves bona fide questions of facts. Therefore, the state also agrees, insofar as my prayer for.
My blessed lordship. My lord, your lordship may kindly see the order dated 15/12/2023, passed in this writ petition.
Ah.
15/12/2023, in the last paragraph. By this order, the so-called notice dated 26/7/2023 has been stayed, my lord.
Where?
Yes, my lord.
26/7/2023.
Yes, my stayed.
Ah.
Now, thereafter, my lord, after this, there is notice. And the petitioner he has not challenged that notice, my lord. The latest, the last notice in the petitioner has not challenged, my lord. In his writ petition also.
Why? After one notice has been issued, again you are issuing another notice.
No, my lord, against this notice, the petitioner has submitted reply.
Understood.
Yes, and that
But I
reply
have
was not
said-
considered, my lord.
Answer initiated against the petitioner in respect to the land of in the so-called notice in the next state. So I stayed. After staying it, what happens?
No, my lord, after stay, in this notice, the petitioner submitted has replied to the notice given by the state. And that reply was not considered by the state, my lord. Thereafter, the last, your lordship may kindly see in my additional in affidavit, my lord.
So for my question is very simple.
My
Question
first,
is, in respect to the land, whether there is an ex parte decree. In respect to the land wherein the petitioner is presently residing, or it is under the possession of the petitioner,
No, my lord.
whether there is a decree or not.
My lord, the prefix. The department, the state has acquired the land in the year 1970. He is the petitioner landlord. Has filed a civil petition claiming that land in the year 2007. That is, the petitioner landlord has claimed after 37 years. And my lord, till date,
But the
till
question,
date,
but
my
the
lord,
question, Mr.
yes,
Whether there is a decree in respect to the said land. My question is simple.
ex parte order was passed.
Understood.
And
Ex
that-
parte order is also a decree.
Yes, my lord. But
Whether
my lord,
it is in respect to the said land.
your lordship may kindly see that the ex parte has been
Yes, others
dismissed,
may
my
go,
lord.
please. Others may go. You don't know. This is the last item, I think. Others may go. I am in the midst of two heaters, and I don't want the you are not having the heater. Maybe accustomed to the phone, it's a different thing.
Your lordship may kindly see page number 63 in the writ petition, my lord. Ex parte order passed in civil suit number 2 of 2007 has been set aside, my lord.
Huh?
Has been set aside. Your lordship may kindly see this page 63. Page 63, the last paragraph, 68, the operative person.
Ex parte order in
The ex parte judgment dated 14/7/2008, was in civil suit number 2007 is caution set aside.
Then
So, my lord, these the petitioner which saying that ex parte has been has been caution set aside, my lord. And so it does not hold the fields, my lord.
no. Page 63 is that order. What is the
Yes.
date of the order? 22/3/2010. Isn't it?
Yes.
Now kindly come to page 70. An appeal there against is filed. The appeal is allowed, the judgment and order dated so and so is set aside. Meaning thereby, the decree which has been passed against him is restored. Then another suit.
Yes, my lord.
None appears for the plaintiff. None appears for the plaintiff. Again, that person files. You are not this.
No,
Who has
This
filed
is
this?
the third person who challenged the ex parte decree.
He files now a suit.
Yes.
Yes, my lord.
And it was
At the stage, as per the record, the suit was fixed on remand. However, no proceedings occurred and no steps taken in view of the suit for displaying. Matter over. Then,
And my lord, this person has filed a writ petition before the single bench, and the court has given direction.
now, show me another thing, Mr. Counsel, instead of doing all these things. Whether the ex parte decree, where's the decree?
Page number 58.
So this decree is against the government. Then,
Now, my lord, here the state is in possession, my lord.
No. We are in possession before they issue the eviction notice to
are you
us.
saying that
the owner, my lord. Is the real owner, my lord.
are
Because
you saying that the state is in possession?
no, but only the disputed portion is yes.
So
in the-
then you cannot. But if you are in possession, the proceedings is bad. You cannot initiate because it is only for eviction of unauthorized occupants. If you are in possession, how can there be possession of an unauthorized occupant?
My lord, here in the
We do one thing, we will look into it again. You look into it, but next day I will allow it. Thursday we will allow his petition, unless you come up. Getting a stay in my court is a big thing. He has got a stay. That is, something is there. Otherwise, I don't grant the stay. It's a bona fide dispute. You can very well file a suit. But here, this is the problem. You can very well, the state of secretary to the government, Department of Transport and Communication. State of Nagaland is a party. Go for setting aside this decree. But anyways, I am not here to advise. Thing is good.
my lord, here,
They also say,
yes, my lord.
the weather also say, don't do further prolong the dispute today.
My lord, it is admitting that state has not challenged this ex-party order. I admit it. We have not challenged. However, my lord, the landowner, that land was acquired by the state government, and that land was allotted to the NST department, my lord, in the year 1970. And the state government purchased the land from seven landowners. And that seven landowners, in among them, the person who is claiming the land is not in the list, man. The lordship may kindly see the landowners.
To him, he is occupied. He is in possession or the occupying that land on the basis of a sale being made by the plaintiff.
And my lord, why the eviction order was issued, my lord? Alex, in the year 2000, in the year 2022, the NST department has lodged a complaint informing the state government that some person is encroaching the land. Upon that complaint lodged by the NST department, eviction order was issued, restraining order and eviction order. Thereafter, in the same year,
Thursday, 2 o'clock, we allow him come up with better arguments. Thursday, 2 o'clock, we allow him. Otherwise. Today I don't have the time, otherwise I would have allowed. Thursday, 2 o'clock.
Thursday.
2 o'clock. I'll allow him unless you come up the good case. Let me also think about how to protect the state.
Absolutely.
Let me also think what is to be done.
Yes, madam.
But you have a big problem with that. The order doesn't seem to be so encouraging by the civil court, but the fact that you did not do anything. It is the state against the state. So it went ex parte. If the service was not properly given, you need to go for setting aside. And setting aside will take a long time. It is done by whom? Kohima. So the Kohima CPC did not apply at that point of time. At that point of time, CPC didn't apply, I suppose. 2007? No.
No, not in full.
So not applied at that point of time. So when the decree was passed, CPC didn't apply. Let me think what can be done. Okay. Then what can we do? In the meantime, you also think to let both of our brains work.
Yes, ma'am.
How to dismiss his petition. But I think I should allow his petition.
As long as the state can file a suit, as long as there's a position, and not the petitioner filing the suit.
State has a problem in filing a suit because it goes against him.
Yes.
But anyways, it's a different thing. I also understand. You are saying very simply that the state can file a suit, but the state cannot file a suit taking into account there is a decree against the predecessor. List the matter on so and so at 2 p.m. Yes, council, you're waiting.
Much knowledge.
Into this item 29. Since tomorrow is PP, so if you're watching allowed to appeal on Thursday,
Okay. What is the matter about?
it's a connection with the suspension of employee.
Okay, we'll take it up on Friday. Let us take it on Friday.
Why if the court is convenient for me?
Huh? Okay, because Thursday I've fixed a lot of matters. Let's have it on Friday. Okay, Friday. Yes, Mr. Counsel from Delhi. What do you have to say?
My lords, item 23 and 24, as per the last order, the respondent number had to file a reply, and that was the last opportunity that was granted. No reply has been filed till date.
What is
So
the
my humble
23 and 24? 23, 24. Yes. What is this matter about?
My lord is regarding a GST matter wherein they have issued some notice and we have challenged that particular notice. We have paid certain amount under protest,
What notice?
demand notice. They have what has happened in this particular
There's an
case, my lords.
ordinary means already there's an adjudication being done.
My lords, there's a stay in effect
I'm
as of
asking
now.
you whether an adjudication has already been done.
My lords, they have issued DRC
There
01.
an order in original, Mr. Counsel.
My lords, just there is no order. They have issued DRC 01A, which is the determination. They have given show cause notice under section 74, and there's a demand notice, demand order.
How
There's
can
no
it be
particular order per se.
sections?
That is
This is for the financial year.
there are multiple financial years clubbed in the matter. Financial year 2021 to 22-23.
Okay, so 22, 23. This will be done under 74. That is suppression.
Yes, my lords. There, whereas they have
Suppression. It is a so-called notice issue. This is the notice under 74(1).
yes, my lords.
As per 74(6) or 5, has the order been passed?
No, my lords.
Then what are you
As per
looking into it?
my lords, we have challenged the show cause notice itself along with DRCs. My lords, what has happened in the present case is we we had there was an employee with us who was taking care of the entire GST filing. He has done fraud on us,
So
wherein
it's a question of fact. It's a question of fact. Go there. Why a show cause notice is being challenged here?
my lords, there are certain
How
other
can it be a demand
irregularities as
notice? Mr. Counsel, how can there be a demand notice without an adjudication? And if it is an adjudication made under section 74(5), then obviously you go under 107. Why should I look into these matters here?
my
No.
lords,
Yes, 74(5) order has been passed. Order
my
passed?
lords,
So called impute order. Yes, order in original passed. See, you go under 107. Why on earth should we look into this?
my lords,
This
my
is the
senior
case.
would be in a better position.
We don't require other side. This type of matters
My
is
lords,
very
my lords, my senior would be in a better position. There are
Okay.
certain other
I'm just
irregularities
saying,
as well.
Thursday. List the matter on Thursday.
In the interim order, maybe continue, my lords.
The interim orders, we'll have it on Friday. This is the matter on
Friday.
2 p.m. Interim order passed earlier. Shall continue. Silent interim orders.
Obliged, my lords.